Good morning and welcome to the House Natural Resources Committee. Today is February 27th. We're going to call the meeting to order. Madam Committee Administrative Assistant, would you please call the roll?
Chairman Guyman.
Here.
Present. Representative Ogeron.
Here.
Present. Representative Bryant. Present. Representative Carrier. Present. Representative Chasson. Representative Coates. Present. Representative DeWitt. Present. Representative Johnson. Representative Kerner. Representative Lacombe. Representative Landry. Present. Representative Mack. Present. Representative McCormick. Present. Representative Reiser. Present. Representative Zarang. Present. 11 members present. We have a quorum.
All right. Once again, welcome to the House Natural Resources Committee. If you would, a reminder to please silence your phones if you haven't done that. If you're going to speak public testimony today, please fill out a white card. I would remind you that any public speaking will have to be related to the agenda items only. So if you're here to speak on any other issue, we're not going to be allowing that. Once again, today we are on some time constraints, so we would ask you to be, members, please be specific and stay on point. Don't be chasing rabbits, if you would. Those of you presenting, if you could keep your presentations to somewhere around 10 minutes, we would be very grateful for that so that we have plenty of time for questions and answers following that. Members, we will also be working through lunch. Lunch is provided for you. You can come and go into the ante room to enjoy your lunch as you see fit. In any visiting of our colleagues, any of you visiting, we would be glad for you to join us. We would welcome your questions as long as we have time for our committee members to get their questions answered first. But we welcome you to join us as well. With that, we're going to get started today with the probably most interesting agenda item, eminent domain and all the things related to it. So we'd like to ask to come to the table Professor Keith Hall and Tommy Smart. And if you guys could again try to keep your presentation to somewhere around 10 minutes, we would appreciate that.
Well, thank you, Chairman Guyman. My name is Keith Hall. I'm a professor at LSU Law School, where I'm director of the LSU's Energy Law Center. Before joining the LSU faculty, which I did in 2012, I practiced law for about 16 years, and before becoming a lawyer, I worked as a chemical engineer for about 8 years. I've worked on a number of issues relating to carbon capture, but I was invited to speak particularly on issues relating to eminent domain. I prepared a PowerPoint that I could use if we've got the ability to bring it up. Okay, and but I can start with Louisiana Revised Statute 30:1108 provides for eminent domain as a means of acquiring rights-of-way for pipelines that would be used for carbon capture and storage, as well as subsurface storage rights for carbon capture and storage. And wanted to begin by talking about why you would even need to acquire subsurface storage rights, and then talk about how Louisiana law compares to some other states. And so I want to hit on the subsurface ownership, pore space ownership, as well as the potential means of acquiring the right to use pore spaces as then the pipeline right-of-ways, and then potential disputes between operators of oil and gas rights and CCS projects. And of course, with carbon capture and storage, you are injecting CO2 into the subsurface, where it will go into some formation where the intent is that would be permanently stored. And this is not going into a subsurface cavern like a salt dome cavern or a big open space. It'd be into the pore spaces of rock. So if you imagine a lot of sand particles, for example, that are kind of amalgamated or stuck together, but with spaces between the sand particles, almost like if you dumped a lot of marbles into an aquarium, there'll be spaces between the marbles. The CO2 will be in the spaces between those subsurface particles. And So what rights does a carbon capture and storage operator need? Well, you'll need the right to store in the subsurface, and you also need, if the source of the CO2 is not from the same site where you're injecting, you'll need the rights of way to have a pipeline to carry the CO2 from the place where it's captured to the injection site. And so those are the two basic rights. You also see some carbon capture and storage operators bargain for a prohibition on anyone drilling through the carbon capture and storage reservoir. For example, a prohibition on anyone drilling for oil or gas to an even deeper reservoir. If you do your drilling right, you can make the well sealed properly, so there's no transfer of fluid from one formation to another. But there are some of the financial incentives, particularly some of the financial incentives if you want to make a biofuel, such as in Caldwell Parish, and then sell that potentially in California. Some of the tax incentives from California that you can stack on top of the main federal income tax credits, the main driver for CCS. Some of those California credits you cannot get unless you have a prohibition on anyone drilling through. So that's why some CCS operators will, in addition to acquiring subsurface storage rights, will seek a prohibition on anyone drilling through. So why would you need to obtain pore space rights? Why not just inject the CO2 underground? And it gets to who owns the subsurface. And so imagine that, as in the diagram, I'm a CCS operator on the tract of land called Blackacre, and I drill a well there. Assume I own that tract, and so I have all rights to operate on the surface and subsurface and inject CO2, but that CO2 plume spreads in the subsurface and eventually goes to beneath Whiteacre. The issue would be, would the owner of that neighboring tract have some basis to complain? And potentially so. Under Louisiana law, Civil Code Article 490 says that if you own the subsurface, you're presumed to own everything directly above or under the ground. So if you own the surface, in theory, you own all the way to the center of the earth. And and sometimes you'll hear people refer to this Latin phrase that's shortened to the ad coelum doctrine or the ad coelum doctrine. People pronounce the Latin in different ways, but basically the different ways of translating it. But my favorite translation actually comes from a federal court over in Lafayette that says, "Whoever owns the soil theirs up to heaven and down to hell," which to me is a funner way of saying it than to say you just own up into the sky and down to the center of the earth. And this way, when I'm teaching my students, I can have little drawings at illustrating that I supposedly own a part of the pearly gates, but also part of the other direction. So it's well established in the law that if there is a subsurface intrusion into your neighbor's subsurface, at least with something solid like a well bore, the well pipe, that's a subsurface trespass. Now, it's not absolutely clear that if you're talking about the migration of fluids at deep levels, that the same rules would apply, and that would be a subsurface trespass. But there's a very good argument it is. Like with a lot of things in law, it's not 100% clear. And if you're going to do $hundreds of millions project, a CCS project, you're not going to do that project and just hope that it's not a subsurface trespass. So because there's a very good argument that it might be a subsurface trespass, if I cause CO2 to go into the subsurface of my neighbor's tract, I'm going to want to acquire subsurface storage rights, just like a big shopping center developer will want to make sure he really has title to the land where he's going to develop the shopping center and may even get title insurance. So similarly, a CCS operator is going to want to acquire the pore space rights of everywhere where they think the CO2 plume will spread. How would you do that? Well, one way is by a voluntary agreement, and we're seeing that. The state of Louisiana has granted about 6 pore space leases. They're called operating agreements for certain reasons dealing with the statutory authority, but basically they're leases. The state of Texas has granted one, the Wyoming has granted a couple, and you also see there are also some private agreements. Could be done with a servitude instead of a lease, and there are some of those. But basically, one way to acquire the rights would be by voluntary agreement. But CCS operators might not always be able to obtain the subsurface rights, and it's not like you could instruct the CO2 to just go around the property if you have someone who is not willing to grant the subsurface rights for their property. And for a lot of projects, pipeline projects, electric transmission lines, to avoid the problem with holdouts, we allow the use of eminent domain. And arguably, with CCS, it's even a stronger reason for CCS, at least arguably, because with a pipeline, you could take a dog leg in the pipeline. It might not be very efficient, but you could to work around holdout landowners. But with a CCS project, you can't instruct the CO2 to bypass someone's property. And so a couple of states, about a dozen states have provided means for CCS operators who've gotten their permits to use the pore spaces of landowners who haven't contracted with them. There are a couple of different models. One is an eminent domain model, and Louisiana and Alabama have done that. And this would be modeled on, say, the Federal Natural Gas Act and more than 20 states that authorize the use of eminent domain to get subsurface storage rights for purposes of natural gas storage in the subsurface. And so that's very widely used for natural gas storage in the subsurface, so it's a very plausible model that's widely used. And of course, for pipelines and for telephone, power lines, we're used to using eminent domain, and so Louisiana and Alabama have authorized the use of eminent domain for both the pipeline right-of-ways and the subsurface storage. And this slide here is just the particular Louisiana statute that does that, and this slide is just noting some of the eminent domain statutes Louisiana has for other types of pipelines, as well as the fact that the Federal Natural Gas Act authorizes eminent domain both for pipelines and subsurface storage of natural gas. Here's a list of the 10 states that have chosen a little different route to authorize CCS operators to use pore spaces even if they don't get agreement. And these states would authorize eminent domain for the pipeline right-of-ways, but for the subsurface storage, they use a model that's more like oil or gas pooling or unitization, where if you have your permits, you wouldn't purchase an easement or a servitude for the subsurface, but you would share revenue, kind of like with oil or gas pooling or unitization. And in case there are some committee members who are not familiar with oil and gas pooling or unitization, I thought I'd briefly explain it. Under oil and gas law, one of the basic principles is called so-called rule of capture. If I have an oil or gas well on my property, I'm entitled to all the oil or gas that's produced from that well, even if it drains from the neighbor. And of course, oil or gas would drain from an area surrounding the well. That can create some inefficiencies because if you have a lot of small tracts that are smaller than the area that would be drained by a well, every owner has the incentive to drill his or her own well. So it's a lot more capital spent on drilling. And in fact, in some formations, not only might you spend more capital on drilling than if you drilled, say, a single well, but you can harm the reservoir if you drill too many wells and try to produce so too quickly. So in the oil and gas context, almost all states that have oil and gas activity authorize their regulator to enter pooling orders or unitization orders or both. Often those are used interchangeably, but there's a couple of slight differences between the so-called field-wide unitization for a really big area versus pooling. But the basic concept is by the regulator's order, you could create a unit. Within that area, only one person would be allowed to operate. Other people would not be allowed to operate, but the operator would have to share the net revenue. And you could do the same thing with carbon capture and storage, and about 10 states have said that if you get the permits to operate, will allow you to use the pore spaces of the neighbors, but you'll have to share revenue with them. And Louisiana has not done that for CCS, but Louisiana, like almost all other oil and gas states, does, in the oil and gas context, have authority for the regulator to do pooling and unitization. If you're talking about how would a CCS operator get a no drill through promise, it would have to be from the person who has oil or gas drilling rights. So if there's an existing lease or mineral servitude, the CCS operator may need to go to the landowner to get the subsurface storage rights. But if in addition he wants a promise that no one will drill through, you may need to go to the person who has the oil and gas drilling rights, which may be an existing mineral lessee. And finally, I was asked to talk some about potential disputes between an oil and gas operator and a CCS operator. And there are a few potential disputes. One is that this carbon dioxide in a water environment is slightly acidic. Not incredibly acidic. We drink sodas, which is basically filled with carbon dioxide, but slightly acidic. And therefore, if you're going to drill through formation that contains carbon dioxide hope to find oil or gas at a deeper level, you would probably need to use more expensive steel alloys than used in traditional oil and gas drilling, and also use a different formula for your cement, so the drilling cost will be more. And that's one potential dispute between an oil and gas operator and a CCS operator, is who's responsible for that increased cost. Does the oil and gas operator just have to absorb that, or otherwise? There also can be some disputes about geophysical exploration, the seismic studies that you typically do to map the subsurface. To get your permit to do carbon capture and storage, you're going to have to give the regulator a lot of geophysical information to show the regulator that the formation into which you are injecting CO2 can hold the CO2, and that there are impermeable layers above that that will make sure the CO2 doesn't rise to the surface. And so the way to do that, you would need to do various seismic studies. Typically, oil and gas operators have thought of seismic studies as being a way you explore for oil or gas, and so they've thought of having the exclusive right to do that. Now, there's an argument, some people would say a strong argument, that if you have a legitimate reason to do seismic for some other purpose than oil or gas, it's just like building a road to the well site that's in the middle of a field, that the oil and gas operator can do that, but so can the landowner. So there's an argument that if you have a legitimate reason to do seismic, say to do seismic to map the subsurface to get your Class 6 CCS permit to do carbon capture and storage, that you're not intruding upon the mineral leaseholders' exclusive right to drill. But some mineral servitude owners and mineral lessees are concerned about someone else doing seismic studies, and there'll be issues there. And those are going to be the main issues of dispute. I went through that kind of quick because I was anticipating a little longer, but that's the kind of the basic run through of eminent domain, where that's because of the requirement under the Louisiana Constitution and the federal Constitution that there can't be a taking of property unless it's for a public purpose and with compensation. With eminent domain, and the government can delegate to companies such as electric power companies, pipeline companies, potentially CCS operators, the authority to acquire pipeline rights-of-way and other rights by eminent domain, but with compensation to the landowner from which those rights are obtained. And that's, again, the Louisiana model. But I'd be happy to answer any questions. Like I said, I know I went through that kind of quick.
You're going to have plenty of opportunity to speak some more in a few minutes, I promise you. There are lots of questions, but if you don't mind, let's go ahead and let Mr. Smart do his presentation as well, and then you both can take questions as the members see appropriate, if that's okay with you.
Yes.
All right, go ahead, sir.
Thank you, Chairman Guyman, and I appreciate the opportunity to be here, and thank all the committee for giving us this opportunity. My name is Tommy Smart. I'm with the Onabane Law Firm in Lafayette. I'm the partner and head of our energy section. I'm also general counsel for the Louisiana Oil and Gas Association. My practiced mineral law for over 40 years, and also more in the last few years done carbon sequestration related work. And Professor Hall has already kind of set up a lot of what I had to say, but as you know, under the Carbon Sequestration Act, you have the ability to use eminent domain to acquire certain rights that may be necessary for these projects, for the storage facility and for the pipelines. And what are we talking about expropriating? We're talking about, in the nature of a carbon sequestration project, as you heard yesterday, on the surface, you are going to have some injection wells and some monitoring wells and some pipelines, but the surface footprint is relatively limited. The greater rights that you need are the subsurface rights, the pore space that Professor Hall talked about, and because of the spread of the plume, and you want to try to avoid trespass liability in either case, or being subject to an injunction for not having the rights you need to conduct your operations. So most of the rights that we would be dealing with would be the subsurface rights that are 5,000 or whatever feet below the surface, and a servitude right. We're not, in most cases, taking somebody's property or their surface rights that they need to utilize. And for most of these projects, the companies putting them together are going to get out and acquire and aggressively look to acquire by voluntary agreement the rights they need. And especially the way most of these projects are working out is the companies try to pursue the larger anchor landowners that they can conduct most of their operations on, and then you're looking more to fill in with the smaller tracts that you need. And the reason why you need expropriation or something like it has to do with Louisiana law and the law of co-ownership. Because if you're going to conduct operations on somebody's property, and if it's owned by more than one person, which a lot of property in this state is, because of either people acquiring property together, or more likely somebody acquiring it and then they die and their heirs inherit, and then their heirs inherit, and you get very fractionated ownership, and you don't always know who the owners are. And if you don't have 100% consent from all of the co-owners, then you can't conduct the operation without being exposed for trespass or an injunction for trespass. So it's the reason why you need eminent domain is mostly to deal with smaller interests and airship issues and smaller tracts, and usually not bigger tracts, because companies eminent domain and expropriation is a costly and time-consuming process that they don't really want to go through unless they absolutely have to, and but it's more. It really comes up more with the very fractionated airship and ownership issues and small tracts. And also, like if you get along water bodies, a lot of times you'll have a lot of these small arpent tracts. So you end up with these small tracts that you may need to complete your project. And as Professor Hall says, you can't get the carbon to move a different way. The process to get to be able to use eminent domain, you have to first go through a regulatory process with the Office of Conservation. You have to get a certificate of public convenience and necessity, and you have to go through and make certain showings to get that with the commissioner. The commissioner has to hold a public hearing in the parish where the property is located, and he has to make a finding that the project will meet all regulatory requirements and will not contaminate any formations containing fresh water, oil and gas, or other commercial mineral deposits, endanger human life, or cause a hazardous condition of the property. And then once you get your certificate of public convenience and necessity, then you have to go through a legal proceeding. And as a setup to do that, you will have had to have negotiated in good faith with the landowners and made them an offer based upon an appraisal of what rights they have for just compensation or to compensate for the full extent of their loss. And you've got to provide them with that appraisal. And then you've got to go through the legal proceeding and have the judge find that there's a public purpose and make a determination on the compensation. And again, it's a time-consuming process, and it's something that is used to an extent in other circumstances, for other purposes, but it's not something it's more of a last resort, and I don't think will be used that much. We have had to, and to compare that with oil and gas for a few things. One is, we've used eminent domain, as Professor Hall talked about, for pipelines, for transportation of oil and gas where necessary. We've used it for underground storage, like for underground storage of natural gas, to have the gas available for when it's necessary at swing periods. We have eminent domain for transportation of CO2 for the enhanced recovery projects. And then in the oil and gas sphere, what we started off with originally, if you would be drilling a lease basis well, if you were drilling just on one tract of land without a unit, and you had a co-ownership situation like we talked about, well, they came up in the mineral code with a provision that if you got consent from 75% of the owners and comply with certain requirements, you could go ahead and drill. So we were already dealing with these co-ownership issues in the lease basis context. Then in the context of larger drilling prospects where you formed units either in South Louisiana based on the geology or in North Louisiana based more on just 640-acre sections, but the commissioner has used his police power to form units, and that's how you share in the revenue and expense of drilling for oil and gas. But it's been recognized in that context that you can conduct operations subsurface or surface on unleased on leases on acreage where you don't have agreements that are unleased. It's not done often, and you're subject to having to pay compensation if in those cases, which really hasn't happened because operators try to avoid those tracks. But we've dealt. I guess the point I'm trying to make is we've had to address and deal with those co-ownership situations in the oil and gas context, either through the 75% rule on a tract basis or through unitization and the commissioner's police power. Now, as far as the approach, we've taken initially and statutorily the eminent domain approach, and that's all we have right now, and that's what companies have relied upon to come here and start and conduct projects. In fact, the project in Caldwell Parish is designed, and they came here with that understanding, and that's one of the reasons they chose our state was because of our Carbon Sequestration Act and part of that being eminent domain. And in their project, in their locality, it's of great economic benefit to them, but they've got a lot of cut up acreage and a lot of split up ownership. So for their project, they really do need eminent domain and probably will continue to need eminent domain. We are the Louisiana Oil and Gas Association formed and Brian Hanks talked about this yesterday. We formed a unitization subcommittee where we've got members from other related groups, Lamoga and others, and we've got different law firms and we've got landowners. We've got a large group together that is trying to go through and come up with a unitization process, but it's easier said than done. We're looking at what these other states have done, and we've also looking at what our traditional oil and gas unitization process is, and trying to come up with a balanced approach that would allow us to share in the economic benefit from these operations, subject to sharing in those costs, and have an equitable allocation of those benefits and revenues. But again, it's easier said than done, and we're trying to come up with that process. And then we're going to need to work with the Office of Conservation because they're the regulatory authority, and obviously with the legislature to come up with something that y'all would approve and legislate. But that's going to take time. time to do, and there's a good chance we won't have that, formulated and worked out with conservation and approved this year. So if we need to continue to have eminent domain in the meantime, or companies won't have certainty to do the projects and proceed with their projects. And then even once we come up with, assuming we come up with a unitization program that works for Louisiana, I still think that we will probably need eminent domain for certain projects like the Caldwell Parish project, and one of the differences between oil and gas unitization and CCUS unitization is usually for an oil and gas unit, you form it and it stays in place. And especially in North Louisiana, most of those, like the Haynesville units, those are 640-acre sections. You form the units and they stay in place at those boundaries. With CCUS, what we will probably or may have to deal with, you may think the plume is going to fill up and stay or migrate in a certain area, but it may move. We may have to revise units, and you may need eminent domain for the acreage, for the additional acreage you need. But I think that if we are able to come up with a fair unitization process, that'll be a process that companies will probably use because it'll be easier to do and can fit more with the Class 6, with the process they're having to go through and permit. And I think then there will be even less need or number of times that eminent domain would be used. I think it would take I don't think eminent domain is going to be used a lot as it is, because it's too costly and it's not the best way to proceed. But I think once we have a unitization process, it'll still be needed, but it'll be used a lot less. There'll be a lot less pressure to need to use it. So, and I also, and I can answer other questions on it, but on the issue of mineral operations as opposed to CCUS operations, there can be a rub at times. But I think what that's going to probably need to be, like Professor Hall talked about, there could be some situations where you could have deeper plays where it might be more expensive to drill through the plume, and those mineral owners or landowners they're going to assert their rights or their claims to that cost differential, if you will. And the companies, I guess what I'm saying is that I think it's going to be up to the parties, the operator and party of the carbon sequestration project, to negotiate and work out an acceptable arrangement with the mineral owners or the landowners or the mineral lessees to work out under those circumstances what makes sense to come to the middle ground, whether it's on the cost of the drill through, whether it's shooting seismic or whatever. That to me is going to need to be, every situation is going to be different, and that's going to need to be negotiated, and I think it can be. But they both will have rights to operate on the same tract of land, and they'll have to operate with reasonable regard to the other. So anyway, with that, we'll answer any questions, and again, appreciate y'all taking the time to listen to us.
Fascinating presentations by both of you, very informative, and we appreciate that. I know there are many, many questions, so we'll get started on that. I have a couple real quick. Mr. Tommy, you and just quick questions. Are there any states that are doing carbon capture that have neither eminent domain or unitization?
Not that I'm aware of.
Okay, so they have something.
And the thing is, we're so early on. North Dakota's got several projects that they have, like 6 approved, and they've kind of gone with the unitization model. And there's other states. I think Illinois. Professor Hall may know more about those other states, but to my knowledge, they've either got one or the other.
And
Texas does not yet have eminent domain or pooling or unitization for CCS. There are proposals to do that. Of course, their legislature only meets once every 2 years. So far, the only project I'm aware of in Texas is their general land office has granted a large lease for the state waters in the Gulf of Mexico, and so they were able to get to a single big landowner by going offshore. But I think it's going to make it problematic until they do get carbon capture. I mean, either pooling or unitization. Right now, I'm not aware of any other projects in the one offshore, whereas Louisiana, we've got more projects.
Okay. Mr. Tommy, you mentioned eminent domain being mainly useful for the small landowner pieces of that, where they may be holding out, so to speak.
Yes.
Has that been used here?
Not yet, because we're so early on and we just got
So you haven't had
primacy,
to
and you've
use
got to
it.
get approval from conservation as a prerequisite, and we haven't gotten that far in that process.
You found it to be useful for that, but yet we really haven't done it.
No,
We haven't
I just-
had a need
I-
for it yet, but you think it might be useful.
Yes, it might be, and the thing is, companies don't want to spend all of that money, the millions that it takes to get these projects going and permitted, if they know down the road that they're going to be exposed to a suit to enjoin them. And so they need some certainty, and right now they've got the ability to use eminent domain if they need to, but they're out, projects I'm familiar with, they're out there trying to acquire those
Understand.
small tracts.
Okay. Thank you. Professor Hall, again, very informative presentation. You, I think it was one of the early pages, you had a visual about not being able to drill through. If, for California example, you can't drill through that layer. In other words, a landowner forever gives up the right to have minerals extracted below that layer. Is that how I understood that?
That gets to what the incentives are for doing CCS. The main incentive is the federal tax credit, 45Q tax credit. An additional incentive is that our potential incentive is that California has a low carbon fuel standard. They require anyone who's selling fuel in California to acquire certain credits, and you can either generate these credits through your own activities that will generate credits, or you can buy credits on a market. And so there's an incentive to have what they consider low carbon fuels, and so biofuels can be close to qualifying as low carbon, because I can grow and say corn, or you would suck up some CO2 from the air during the photosynthesis process, but then you'll burn it. And so in a sense, the CO2 is recycled from the air to the corn and then to make ethanol and reburned. But there is some manufacturing involved, and the California looks at this life cycle analysis, and to fully qualify as low carbon fuel, you need to do something with the CO2 that would be emitted when you're converting, say, the corn to ethanol, for example, or like in Caldwell Parish, they're making sustainable biofuels. And if you capture the CO2 that's generated during the manufacturing of converting the vegetable oil to sustainable aviation fuel, or the corn to ethanol, if you capture that and then inject that into the subsurface, then the life cycle would get you under the wire to qualify your biofuel as low carbon fuel standard in California. Then you can generate these credits that you can sell. But under the California rules, if the only way your biofuel is going to get under the wire and qualify as low carbon for the life cycle is by using CCS, they will not let you use the CCS portion unless you've got a promise, a binding promise that there will be no drilling through the CCS reservoir. So if you don't have that promise, it takes you out of the ability to stack on top of your federal tax credit the California low carbon fuel standard. And for example, the Caldwell Parish project is one that's dependent, as I understand it, on both the federal tax credit and generating California credits by selling sustainable fuel, aviation fuel in California.
How would you measure the loss of the future minerals on that property when you were negotiating with that? How would they measure that loss? Because you're saying forever you can't get to those minerals. What future loss could you see, and how would you measure that?
Well, first of all, for instance, in the Caldwell Parish example, they have had very little oil and gas activity, and but you would probably look, and again, as we talked about yesterday, most of these areas where we're doing the projects, you're looking for areas where there has not been a lot of historical oil and gas activity because of the risk of the. But you would look to see if there had been any plays in the area, and what the economics might be for those to try to quantify that. And again, you're gonna, and back up. Most of the projects that I'm familiar with, they're not going for the California credits because it's too hard to comply with that, to be able to put that limitation in place, so that there aren't many projects where that's going to be the case anyway. But then you'd have to again try to quantify what, based upon some value, based upon other plays in the area, and you can also there's, depending upon how big the plume area is and where those hydrocarbons are, you can reach them without penetrating. There can be directional drilling or horizontal drilling to reach those in some instances.
So we could get to the minerals under that layer by horizontal drilling?
Yes.
And you would not lose your California tax credit?
Right, the California prohibition, when it
They just don't want you to drill
would not
through it.
prohibit you from coming if you did directional drilling from off-site, yeah.
Okay, good deal. All right, question, Representative McCormick.
Thank you, Mr. Chairman. Thank you, gentlemen. Has it already been decided that CO2 storage is a public use? Has that already been decided in Louisiana courts?
That has not been decided in Louisiana courts. It is in the statute, but that would still need to be litigated.
How is, we're in statute, are we talking, are you referencing secondary recovery with CO2, or?
In the Carbon Sequestration Act, it makes a statement of that. I forget what.
Yes, the Louisiana Geologic Sequestration of Carbon Dioxide Act the legislature proclaimed that carbon sequestration, now called often carbon storage, is in the public interest.
And when was that act put in place?
I believe it was 2009.
2009. Boy, they were ahead of us, weren't they? Goodness gracious.
There was a lot of interest in CCS about that time, and it died down for a while. But yes.
Right.
But I think it would still need to be litigated.
Sir?
It would probably still need to be litigated. It's not been litigated in Louisiana.
Right, exactly. Okay. Pore space leases that you talked about, we're talking about the small landowners. How are they going to decide how those small landowners are going to be compensated for the pore space lease? Is there something in place? I've been in oil and gas my whole life, and when it comes to the small landowners, they usually get crucified. They can they get threatened with eminent domain. They can't afford the lawyers that the bigger landowners can. It's my understanding other states have put in fail-safes in place where the small landowners will be compensated as the greatest amount of that any landowner is compensated. Do we have anything like that in place in Louisiana?
There's nothing in place now, and that might be part of the unitization process. It's an individual case right now. As far as I'm aware, most of the other states, what they do when their unitization process is their agency, like the commissioner, has to make a finding that the allocation is fair and equitable. There's not necessarily a floor, but they're going to come up with what any non-consenting owner gets paid, and that's what the commission will find that that's fair and equitable. And that would probably be part. We'd have to figure out how to do that as part of the any unitization plan. But right now it's but for instance, in the Caldwell Parish project, it's my understanding that they've already gone to the mineral board and gotten approval for what they're going to pay the state on a per acre basis, and they're going to pay everybody based upon that. So
how large is the Caldwell Parish?
I don't know.
I think it's pretty small, if I'm not mistaken. Was that in your area? Yeah, I was thinking. Right. I remember some legislation we passed. It was fairly small, for that particular.
In this instance, and there is to an extent an incentive to pay the smaller owners on a higher rate, just to get to lock up those interests and not have to go through the eminent domain process.
Will that be public knowledge what the larger landowners are getting? I mean, how will we know how to compensate the smaller landowners?
Whoever does the appraisals will have to try to get that information. Whether that'll be public or not, I don't.
Yeah,
It's usually private transactions, but they're also sort of like going rates, like there was talking about yesterday that of I think it was $1.50 a ton. And that's kind of you see in some of these other states the what they're awarding. So there'll be some information out there on what's being paid. Now whether it'll be detailed in each instance and all.
Yeah, there are the 6 leases granted by the state of Louisiana and the one by Texas and a couple by Wyoming. And so those I know firsthand from talking to people that those have been used as reference points in some of the private negotiations. And I suspect if you got to an eminent domain proceeding that the appraisers would be citing those as evidence.
Yeah, that is my concern moving forward. And, I think sometimes we may be moving so fast that even what we consider large players in the past in Louisiana are now so small because they're up against these billions of dollars. And as you said, these laws were put in place in 2009, and I wasn't even thinking about carbon capture then. So that does concern me that we're putting speed in front of the private property rights, which is something that I think that everybody in this room is concerned about. So it seems like that legislation could be put in place fairly quickly if we wanted to. The other thing that I am concerned about is the stranded reserves underneath these plumes. I've heard of some of these plumes maybe being 30,000 acres, and I'm sure you are aware of that. Vertical drilling for oil is way more efficient and cheaper than horizontal drilling. I mean, horizontal drilling, as y'all know, good as me, that is the technology is only recently advanced to where we can horizontal drill, and you cannot horizontal drill underneath the 30,000 acre plume. You may get on the edges. Do we know how are they going to, we talked about these plumes. We know for a fact that the CO2 is going to go the path of least resistance. Now, we can guess where that is ahead of time. How are they going to monitor that, how that may be moving on other people's property and creating a trespass they don't even know that may be there?
And I'm not a scientist or whatever, but as part of this process, they're going to have monitoring wells because from an environmental standpoint in the Class 6 process, you have to monitor and track where it's going, and you have to periodically, every 3 years, 5 years, or whatever is determined in that proceeding, you've got to have the monitoring wells and probably shoot some seismic to keep track of where the plume is going, because that's an important part of the regulatory process is to identify where that plume is going.
Yeah,
right. Okay.
Mr. Smart's correct. In addition to the upfront modeling, the Class 6 regulations require monitoring wells during the process of injection and then continuing to monitor for another 50 years or so after the injections have ceased to see if the plume is stable or still spreading.
Yep. Well, I would like to add this. I would like to see some legislation put in place to protect the small landowners when it comes to eminent domain, what they're being paid. I'd like to see some legislation put in place to protect the mineral owners that maybe had loss to their minerals. And would love for somebody to bring me that legislation and say, hey, this is good legislation, or we can get together and I can figure out how to draw up my own, which may or may not be great. But I do think before we move forward, that needs to be a discussion. So just if you know anybody that'd be willing to help me, I'd be more glad to work with them. But I do think that protecting the private property rights, I think, is the most important thing over here. Chasing billions of federal dollars, I don't think is the most important thing. But I do appreciate you. Your presentation was great, and I appreciate all the work you've done. And thank you.
Thank you. Thank you, Representative McCormick. Vice Chair Orgeron for a question.
All right. Thank you, Mr. Chair. Thank you, Mr. Hall and Mr. Smart. Excellent testimony. The question space that I'm going in is, you mentioned about eminent domain being kind of plume migration outside of the perceived area or the expected area. And something, Mr. Hall, you said was about the reservoir, and I would imagine just like with oil and gas and water, traps and seals basically is where they're contained. And in tests where we've put in CO2, or supercritical liquefied CO2 into the same areas or the proposed areas, is there anything geologically unique about Louisiana that assures that it stays where it needs to be and you don't have any sort of, I guess, reactions like I was looking at basalt type of sequestration, where it's more of a type of reaction that it's stored and held in. We don't have any of that here in Louisiana, do we?
I'm not aware of that. I'm not the geologist. I do try to keep up with the science to the extent that a lawyer with a little bit of a technical background can. The geologists say that we're ideally suited, and the fact that we've got so many reservoirs that have contained oil or gas, therefore are porous and permeable, is evidence of that. Also, the fact that unlike, say, California, if you think about the La Brea tar pits or some places where you get seeps all the way to the surface, in Louisiana, a lot of our oil or gas has been contained for millennia.
Right.
And so some of the same cap rock or seal rocks, you'd be relying on to contain the CO2. But the geologists would probably do a better job than me in talking about those things.
And that was part of the presentation yesterday afternoon where he showed all the layers.
Yes.
And you'll
Chris
have,
McClendon with the deltaic deposition of layers of sand.
So that's what we're
sand,
depending upon, is those layers.
That's what I was looking for. We don't have those particular issues where, let's just say, unexpected transmission could take place.
No, you're looking,
we're more consistent.
You're looking for the layers like he showed yesterday, and that's looked at as part of the regulatory process. And if there happen to have been any wells drilled or whatever, they look to make sure they're properly P&A'd. They're not looking for faults or anything to let the CO2 come up. So that's all part of looking to make sure it's sealed off.
Got it. Thank you. That's what I wanted to hear.
Thank you, Vice Chair Orgeron. Representative Landry for a question.
Thank you, Chair. Professor Hall, thank you. Mr. Tommy, thank you for coming again today. I do have a question on, and I think I know the answer, but I want to get a little clarity. So when landowners would go in and buy large lump sums of land, but then the original owner would sign a deal with retaining 10-year minerals, on CCS, would the surface owner therefore override the minerals when it would come to the?
In my opinion, the surface owner owns a surface. Whoever reserved the minerals or he conveyed the minerals to has a mineral servitude. They both, under the mineral code, there's a provision that's what's referred to as correlative rights or accommodation or whatever. They each have the right to operate on that piece of property with reasonable regard to the other. And that's why I'm suggesting that what they do in those situations, if there is the possibility of mineral development or they're concerned about shooting seismic or whatever, the prudent operator that doesn't want to expose themselves to that risk negotiates an accommodation agreement with that mineral owner to deal with that situation, whether it's to allow development or pay him for his part of the minerals or whatever they're able to come up with that makes sense for that tract of land.
Yeah. The landowner, the consensus is would still be the person who had subsurface storage rights, because that's something different than extracting oil or gas. But the mineral servitude owner would have the right to extract oil or gas, and so there would have to be some reasonable accommodation. So if you're a CCS operator, you would need to get the subsurface storage rights from the landowner, but that you'd have to be cognizant of the mineral owner's rights to explore and produce.
And it's somewhat, while different, it's like what they're having to do with the solar projects. They're having to, if there's a mineral servitude outstanding and somebody wants to do a solar project, then they've got to go negotiate with the mineral owner as far as what surface rights they may need or whatever, because they're wanting to conduct operations on the same piece of property. So they've got to come to an agreement on how to do it.
Thank
or
you.
they're exposed to the risk of the other.
And then when I think 10 or longer years down the road, let's say technology prevails and and they start extracting CCS for some other reason, but who becomes the mineral?
For the carbon, the CO2 that's in the ground, that is owned by, would be owned just usually under the agreements contractually by the operator that injects it, and then it's later turned over the way the statutory scheme works. When when you do your certificate of completion or whatever, it's turned over to the state. So neither one really.
Gotcha.
At that point.
Thank you.
Thank you, Representative Landry. Question, Representative Coates.
Yes, thank you, Chairman. Thank you, gentlemen. Question, so I just want to be very clear for the public. So eminent domain was the power of the government to take private property for public use for compensation. But Louisiana has given the rights to CCS projects to use eminent domain to acquire those surface rights, even without that person's approval, correct? They can, like, the CCS can go to court and take those rights away from them.
If it goes through the procedure, it can acquire those rights and others. It's not just like for the state can do for roads or anything else, and we're not the only state that's given companies in certain non-governmental entities the right to expropriate.
Right. Yeah. It is the authority of the government, but it can be delegated to companies, and that's been the case for and tested and upheld in court. For it's done in pipelines, electric transmission lines, so that's well established, and under then both their federal statutes and statutes in all 50 states that delegate to companies.
Well, I believe that the power is good for the people and the public, but I don't know about the carbon, but that's my personal opinion. So, I've been dealing with this for the last few years in my area, and over many meetings, we've been told the plume is not going to move. That's why they have to do this seismic. That's why that rock has to be there, that the plume is going to stay there. If it starts to move, they're going to shut it off. But now we're hearing that the plume is going to start moving, and now we're going to have to take eminent domain on the neighbors.
No, well, those are somewhat different issues. With all due respect,
Okay, please explain.
As far as the plume not moving, I think the concern from a safety standpoint is it moving up, which it leaking to the surface and causing any health concerns or whatever. The plume injected into the ground, we model and we think we know where it is, but it may move. And so that's why you have larger tracks, and that's why you have and that's why we need an eminent domain, because the plume may move. And they model, when you inject, it fills up and then it may move some. I don't know if that answers.
No, it does, but that's still not what we've been told. There was the health concerns of it moving up, but there was property owners on the outside around this project that were concerned it was going to go under their property, and they had no say. So now you're saying that it can happen, and then the eminent domain would be taken.
It may be necessary, and I don't know what was involved in that particular situation, and especially in terms of where the injection wells were compared to those properties and all, because they may be able to know that it won't move that far, and they also look at the geology and can tell based upon, and I'm not a geologist, but they have an indication of if it's going to move, which way it's going to move because of the dip and formations.
But the seismic is private, so no one can even look at the seismic to see those neighboring property owners.
I don't know all the details of that, but they will have to be submitting that they will have to periodically do that seismic and periodically share that seismic with the Office of Conservation, who will be monitoring all this. So there will be.
But not the public.
To get the permits, the seismic would be shown to the Office of Conservation, which is going to want to see this extent of the plume spread, and that it'll be contained in the sense of not moving upward into underground sources of drinking water.
And again, I realize this may not answer or solve your concerns, but just by way of background, generally speaking, in the oil and gas sphere with seismic, it is treated as very confidential and valuable and protected because of the value that it has for companies to utilize. And so there's usually stringent license agreements and everything that are set in place. And I know
But
that doesn't.
CCS is new.
I know, no, but I'm
this
just.
is going to be moving.
No,
so
I know. I'm just giving you
I
background.
understand.
Okay.
So Louisiana follows a risk charge approach. Can you kind of explain?
Okay. That is in the oil and gas context. We started off with you drill wells, you'd have a unit and you'd want to drill a well. And what would happen sometimes is that, and units have multiple tracks, and so what would happen sometimes is you would have what some people refer to as lease busters that would come in and lease. Somebody would try to put their prospect together, and somebody else would hear the play was going on and go lease tracks within the unit, but then the operator goes ahead and drills the well and takes all the risk and expense of drilling the well while somebody else rides them. It's also referred to in some states as a free rider. So what we did was we came up with a situation, and it's evolved over time, what's referred to as the risk charge statute. And under the risk charge statute, when in the oil and gas context, when you go to drill a well, you send out a proposal and you say what the cost of the well is going to be, and then if there are other lessees in the unit, I'm not talking about mineral owners or landowners, but if there are other lessees, they can elect to participate, but then they're in for paying their share of the cost of the well. If they don't pay their share of the cost of the well, to discourage them from free riding, there may be penalties like a 200% or 300% penalty because the operator's taken the risk. Or if that party elects to pay but then doesn't come through with paying the money, they're subject to the risk charge. In the oil and gas context, because unleased owners are relatively rare. The landowners, the mineral owners, the unleased owners do not bear. They have to. What happens is if they're unleased in a unit, they don't bear any penalty, but they don't get their share of the revenue from the well until the costs of drilling the well have been recovered. Then they come back in after that. So does that answer?
Yes.
Okay.
I just want to get this out there.
Okay.
So I think, can you explain, so, there's going to be different layers and amount of carbon under this cap and stuff. So if there is a section, because I read your paper, if there's a 500 feet thickness, how will that be compared to someone that only has 100 feet, under somebody else's property?
Okay. I think you're referring to a paper where I talked about the different ways of potentially compensating landowners who did not come to an agreement. If you come to an agreement, then I guess your agreement with the CCS operator would control your contractual basis. And that was if the state went to a unitization model as opposed to an eminent domain. An eminent domain model would probably be a one-time purchase, and for the purchase price, the appraisers would try to take in what they expect the future revenue to be, because that had to factor into the value, but to be a one-time purchase price. If we went to a unitization type model to compensate landowners who haven't come to a contract with the CCS operator, the question would be, on what basis do you compensate them? In oil and gas pooling, you typically do it on a surface acreage basis. So if you have a 40-acre tract in a unit, a drilling unit, and I have a 20-acre tract, you would get twice as much because you had 40 acres as opposed to I have 20 acres. But with what's sometimes called field-wide unitization, which is the process that's authorized by Louisiana Revised Statute 30:5, and which oil and gas scholars call field-wide unitization or unitization as opposed to pooling. Because you're over such a broad area, they do take into account that not all parts of the formation may be the same. So what if you had 40 acres and I had 20 acres, but the reservoir is thicker, twice as thick beneath my property, then I might have as many if you took the volume, area times height, I might have just as much reservoir as you. And so in the field-wide unitization of the type authorized by Louisiana colon 30:5, which is not the pooling authorized by 30:9 and 10, under the field-wide unitization, the regulator typically considers a number of factors, acreage as well as thickness of the reservoir. And I think the rationale is if you're talking about a really big area for a field-wide unit, there's more chance of variation over a big field than over a smaller drilling unit that you're going to just use the pooling authority. And that's what I believe I was referring to, that if you did unitization with CCS, it'd probably be a large enough area that you might want to do the compensation on a more complex formula than just surface acreage. You might want to take account of would the surface, what's the thickness of the reservoir between your land versus my land in addition to the surface acreage.
But you may want there is most of the states seem to be going more for surface acre basis, and in North Dakota, where they've already got 6 projects approved, they're going with surface acre basis. And one thing is, it would be hard to, in those reservoir-wide units, you've got more mature fields where you know more of what the geology is like and what oil and gas is there, and it's easier to model, and it's fixed in time. But if you, in these, as you fill up and as it goes like that, and as it might migrate, you're going to be doing the monitoring wells and everything to tell where the plume is, but to try to start changing that every time you model and that how you share and pay along the way, it could get administratively cumbersome, which I think is why, and plus you need agreements on that acreage to do your project, whether some of it's storing this much and some of it's doing that. So all of the project is valuable. So that's kind of why it may make more sense to go on a surface acre basis.
Yeah, I'll just add, in places where the reservoir or field-wide units are used, one of the drawbacks is it's often difficult to come to the formula because, the different people all have a different idea of what the formula should be, and go figure, person A's idea of what the best formula is the one that happens to get him the most money, and there are all kinds of factors. So simplicity is one of the benefits, particularly when there are pros and cons of different formulas.
And I think more of the oil and gas reservoir-wide units that are done these days are done more on an acreage basis, from my understanding from one of the unitization lawyers in my office.
Well, I just wanted to ask, I have a friend that owns a couple hundred acres, and there's about 4 other property owners around him that owns hundreds of acres, and he's the one that doesn't want CCS. And he's being told that you don't have a choice. And so one of his questions is, how much, would I be compensated and stuff? And I've dealt with solar, because solar was brought up, and one of the things with that was if the companies start as the technology improves, and they start generating more power, will the landowners be given more royalties? But no, it's a flat rate. But so that was a legal kind of question coming from.
It depends, and it depends on, if he leased to someone or entered into an agreement, it would depend upon what that agreement provided for and whether there was any escalator provision in there. If he's not leased, if he's a non-consenting owner, then it will depend upon whatever system we come up with, and if there is however the revenue streams are calculated, and if they increase over time, how those are shared, and we don't know that at this point.
So who is going to come up with this revenue stream?
Well,
Whoever, I don't know exactly, but my impression is that whoever puts the projects together, they enter into agreements like they discussed some yesterday with the emitters, with the plants or whatever, and they enter into contracts with those, and they enter into transportation agreements with the pipelines to get to the project. So it's putting that deal together and the revenue structure that brings the revenue from the tax credits from the emitter source to the project. And I think the economics of the different projects depend upon their structure, and the Caldwell Parish project is completely different because it's tied into the biofuels. So it'll depend upon the nature of the project and the source of the emissions and where the project is.
If I can add, in the unitization context, the regulator has to approve the final formula. Any parties who are making an appearance at the regulatory hearing could make proposals, but the regulator has to approve whatever the formula is.
That's likely the way it'll be, yeah.
And will that flow through to the ones that are holding out?
Yes, and of course, at present, we only have the eminent domain, not the unitization. But if we went to the unitization model, that would have to, the order of the regulator would say what the revenue sharing is for all the tracks in the unit. And so that would account for.
But we do not use that.
Not yet, because
present,
we don't have, we got to figure it out.
Okay. Thank you, Chairman.
Thank you, Representative Coates. Representative Mack for a question.
Yeah, just a couple of quick questions. You might have touched on this already, but what is the process to compensate an adjacent private property owner? If the plume shifts, right, and it's discovered that it shifted, and it moved under the subsurface of a adjacent private property owner, what's the method to compensate? How does that process work again?
Well, they would first, well, they're going to try to model and identify any places where they're going to need to acquire additional agreements so they're going to try to anticipate that ahead of time and negotiate with the landowner. And if it happens, they find out afterwards, they'll try to negotiate with the landowner. If they can't reach an agreement with the landowner under our current statute, there would be eminent domain, and they would they would have to negotiate in good faith with the landowner and make them an offer based upon an appraisal on what that appraiser thinks that the value of that right, is going to be. And then they'd go through the legal proceeding. If we come up with a unitization plan, then it would probably need to address the potential for revision of the unit and what would happen in that instance.
Thank you for that answer. I appreciate that. So what I'm understanding is that the adjacent property owner would not have to prove that the plume shifted, that it would be kind of public record or communicated, or there would be a plan,
I don't know for sure. It probably would, because that's the purpose of reporting, reporting to conservation, where monitoring where it's moving and all. And so you would have to go acquire those rights, I believe. And also companies aren't going to want to undertake that risk and have that potential liability without dealing with it.
Thank you for that answer. One last question. So if somebody's private property was taken, through eminent domain, and then unintended incident occurred to the point that there was significant, non-economical loss to their private property, how would that adjacent private property owner be compensated? Would that be through the courts, or is there?
I believe I don't know. I believe through the courts.
You could still have your tort claim.
Right.
The kind of lawsuit that anytime someone has an accident, because the eminent domain would not absolve the operator from operating responsibly and not having a negligent accident. So yes, there'd be a potential. There would be a court claim if assuming the parties didn't settle for the damage, there'd be a court claim for that in tort law.
Thank you so much. Just reflecting back on the Bayou Corn incident, I was reading in RS 30-1109 where it talked about civil liability and a cap on civil liability for non-economic loss being of $250,000. There's cases where somebody could lose private property and it be, much higher than that, a loss much higher than that. If that was handled through the courts, would that be capped off at $250,000? Would that be the maximum amount that they would be able to be compensated?
Well, the property damage would be a sort of economic loss. And so.
Oh, it would be an economic loss.
Right.
Okay.
And so that would be, if you had a loss of property or diminution in value of the property, lost earnings if someone was injured. The non-economic things would be like pain or suffering or something that you can't put an economic,
Okay.
Courts do put a dollar value on it, but that's not something like strictly money value.
Okay. Thank you. Thank you, Mr. Chair.
Thank you, Representative Mack. Question, Representative DeWitt.
Thank you, Mr. Chairman. My questions, either one of y'all can answer. I appreciate y'all being here today, and thank you for all your testimony. You're definitely getting lots of questions from us, and again, appreciate your patience. Surface footprint size. Are y'all aware when they do it, they find a location? Because I've heard one testify yesterday that they're in my parish. They're going to be actually on Forest Service property. When they drill a well and then have to drill these monitoring wells, how big a surface area are we talking about approximately? Do y'all have any idea?
I don't know. I mean, a few acres, 10. I don't know. It's not. I don't think it's that large a footprint, but and they're not doing any, major facilities or whatever. But I don't know what kind of footprint they need for a well.
Yeah, and I wouldn't be able to answer that specifically either. I'd have no reason to believe it'd be materially different than what you would need to drill an oil or gas well, or what you would need for, you've got in Louisiana thousands of other, say, Class 2 injection wells and other classes of injection wells, and I have no reason to believe it'd be materially different, the acreage but I have to go to more of the technical engineers to say what they would expect.
I see. Because we're talking, I think they testified yesterday, we're talking possibly 8 wells per site drilled, per site, including monitoring wells, to be drilled at a location at one particular area.
And spread over thousands, usually thousands of acres.
That's what, exactly. Wherever they decide they need to be to monitor any type of movement from one area to the next. Seismic impacts, I'm not sure, again, which one of y'all would be the one to answer. Has there been any studies if they've done a particular seismic activity, let's call it, in an area, and they've done some drilling? Is there y'all hearing any studies about possibly any effects on drinking water wells to private wells, or even if they're close enough to houses, any foundation issues that's been caused, and what would they, how would they, person, try to fix that or talk to whoever they need to talk to? Have y'all had any studies to address that?
I don't personally know that, but there's been a lot of seismic shot in the state of Louisiana over the last 15, 20 years, all over the place. So, I mean, I think there's probably evidence or, information on that, but
I talked to the folks at both Department of Natural Resources and also Wildlife and Fisheries, because Wildlife and Fisheries grants some of the seismic permits, and other than allegation of a well, I guess on the North Shore, no one was aware of any allegations of water wells being impacted by seismic surveys, and the regulators that I talked to cited me to a couple of studies of the the well on the North Shore where the conclusion of those persons who did the study was that the well was not, that the cause of that water well problem was not the seismic surveys. And as far as any studies, at the time that I heard the allegation of a water well being impacted 8 or 9, 10 miles from some of the air product seismic surveys, I did some searching, and there's not been a lot of academic studies, which perhaps a reason is because you don't hear about allegations of it very much. I think I found someone's master's thesis that one time at some other school that did a study on it. So there's not a lot of studies and not a lot of allegations of the problems.
And I think the technology has gotten a lot better to where they're not having to, it's not as much of an impact with with the devices to send the signals or generate the signals to. And I think some of that can even be done downhole as well. But again, I think the technology is getting a lot better to where there's less
impact.
Yes.
Yeah. Okay. So does someone know? They talk about that they're going to put many billions of cubic, I think, tons into the ground of CO2 into that cavern. How often would they check to see how often I keep hearing the word plume, so I'm going to use it. How often would that plume be checked to see that it's moving in those monitoring wells that's there? Any idea? Or would that be a regulatory question?
I'll let Professor speak to whatever he knows, but it's my understanding that it's sort of continuous. It depends on the project, but it's sort of continuous, and they've got reporting obligations to the regulatory agencies, and they also have periodic reporting that's established under the permits for those particular projects. I don't know if we.
Yeah, that does get into kind of some of the weeds of the regulatory requirements, but it's my impression that's continuous. The monitoring wells are there, and it's my impression that it's more or less continuous monitoring with periodic reports to the regulator of what's the monitoring, the continuous monitoring is
and the
found.
Companies want to monitor what's happening and how the plume's moving and how their storage is. I mean, they're going to want to monitor it pretty continuously.
Yeah, I see Secretary Gray and them on the agendas.
Yeah.
So that's something I may need to ask them. But why I'm asking, because the citizens are worried who's going to be in their benefit looking out for them, your adjacent landowners, to see if that plume is possibly moved under their surface. So that's why I'm asking. Okay.
Right. Yeah, and the monitoring wells, the regulations come under the Safe Drinking Water Act and are designed to protect underground source of drinking water.
Right.
But in doing that, you're required to monitor where the CO2 plume is going, and that could also catch if the CO2 plume is for some reason going further than expected, and that could also end up protecting adjacent landowners through the monitoring of seeing where the CO2 plume is.
Right. Okay, one last question. How many acres are we talking about? When we drilling, I'd asked about surface acres. How many acres do you think? When I'm a company and I want to go out and look at an area, how many acres you think does it take to be a good site? Let's say, I'm hearing about large landowners. I'm hearing about small landowners. Basically, any idea how big a site we're talking about that these companies are looking for, acres-wise, surface acres-wise, by the way?
I don't have a minimum surface idea. I mean, the state leases are thousands of acres, and the private agreements you're hearing about are where they've gone to like timber companies or other large landowners. But I don't know what would be the minimum site that would be a viable project.
And they vary. I don't think there's a minimum, and it varies on the project and the formation.
That's
right.
Underneath, right?
Right, that they're looking to store in.
That's all I have. Thank you, Mr. Chair.
Thank you, Representative DeWitt. Visiting members, Representative Shammerhorn for a question. We are bumping up on our
Yes,
allotted
sir, Mr.
time, so
Chairman.
if you and the next visiting member could keep it as brief as possible, we'd be grateful. Thank you.
Thank you, sir. Thank you all for coming. Very important questions and very informative presentation. Professor Hall, you had mentioned the different required steel alloy because of the acidity of going through a plume. Okay. And Mr. Smart, you had also referred to the possibility of the added cost being compensated by the owner of the plume at one time. How would the private individual go about putting this in their contract for the storage, like eminent domain, okay? So they just held out and held out and held out, but they do believe there's oil or gas under where you're going to be depositing the plume. So once you deposit it, it increases the drill cost. So is there a way in revised statute 30 that they can require or ask for compensation on the difference of the cost of the drilling?
The eminent domain statute doesn't specify how the compensation would be paid, and if the parties don't come to an agreement, and the eminent domain statutes do require the company first try to negotiate, then it would be up to the court. Nothing in the statute would prohibit there from being, for example, a flat payment with also a reservation of if there was a later discovered oil and gas field that required there being some indemnity of the extra cost. That would be uncommon, but since we're talking about an unusual situation, I guess, nothing in the statute would prohibit there for being, like I say, a flat rate for the eminent domain plus some additional conditional rider that if that happens, there could be an extra payment, and that would be one thing that could be attempted.
I don't think there's anything in the statutes. I think they'd have to negotiate, or the mineral owner might have to sue them and see what the court's decided.
Okay.
Which creates the risk and the need and the incentive to negotiate.
Right. Going along with Representative McCormick's ask for some help on some legislation, I would like to see some of that added in part of the legislation that may be coming forward to make it to where it'd still be feasible if they can get to it instead of prohibited because of the cost. Thank you, Mr. Chairman. Thank y'all for coming.
Thank you, Representative Shammerhorn. Representative Owen for a question.
Thank you, Mr. Chairman. Thank you, gentlemen. Very quickly, are either one of you aware inside of Louisiana law that covers eminent domain? Do we have provisions for other things that deposit waste in the ground? I know we have wastewater wells. Or do you know if our statute provides for the ability to do eminent domain for wastewater wells? I know we can do it for electricity and roads and hospitals and all that stuff, but is there anything else that does waste besides this?
No, the closest analogy we have in Louisiana law is that we do provide eminent domain that could be used for natural gas subsurface storage, where where it's not a waste, but there's an analogy of using the subsurface pore spaces to store natural gas. In the in the waste context, there have been some court cases where plaintiffs have brought suit saying they believe the waste plume from, say, a Class 2 well had come beneath their property, and there's been mixed results. Some courts have said that if there was no actual harm, there was be no compensation just for the fact the plume came underneath, but other courts have let the plaintiff. There's one other case where the court did not dismiss the plaintiff's claim, and then I think the case settled. And I think, as I said, if you're talking about someone doing a big enough investment or a CCS project, they're going to try to lock up the CCS rights. They're not going to just take a risk. But with the Class 2 saltwater injection wells, the companies, to my knowledge, have not done a lot of purchase of pore space rights, and largely have just been allowed to do it, and that has been considered almost like the airspace, where in theory you own the airspace, but I can't charge Delta for flying over my land. I think the Class 2 wells have largely been treated that way. So no, we don't have one for waste. The closest analogy for eminent domain would be the natural gas subsurface
But that can
storage.
be sold. That can be extracted and sold, right? The gas?
The natural gas, that's, if you put in the subsurface for storage, it would belong to whoever injected it. So if I did a storage project and it went beneath your property, you would not be able to drill for that natural gas. But the
No, what I'm
eminent
driving
domain-
at is there's a potential economic benefit to that. This is just dumping waste in the ground. And so there's no other provisions that enable eminent domain to put waste in the ground. This is the only one that y'all are aware of, right?
Yes.
Okay.
Yeah.
Thank you. And for the record, I'm not against oil and gas. I'm just trying to figure this out. Thank you.
Thank you, Representative Owen. The board is clear. Hallelujah. You guys did an amazing job. So much information to share with us.
Thank y'all for listening, and
Very,
thank
very
you for your
informative.
questions.
You guys did great.
Thank you, Chairman
Almost like you
Donovan.
rehearsed it. Thank you so much for being here. I know you have other things to be doing. We appreciate your time. All right. Thank you. All right, next up, we're agenda item number 2, water resources. We have Department of Energy and Natural Resources, and is Scott Eustace here? Scott? Okay. Did you fill out a white card yet? You did, okay. Do you want to?
I had slides, but I don't know if they're working.
What is it?
You want to sit here? Yeah. Sure. Thank you so much.
Okay, so what we're going to do is let DNR present, and then Scott, you can present, and then we'll take questions from the committee for both of y'all. Okay? All right. We are ready when you are.
All right, apologies, 1 second.
I'll go ahead and get started. Mr. Chairman, we appreciate the opportunity to be here today. Today, we wanted to come back and focus on, the specifics around the protection of the underground sources of drinking water. And so again, going to turn it over to Executive Counsel for the Louisiana Department of Energy and Natural Resources, Blake Canfield, to walk through some of the specifics, and then happy to answer any questions afterwards. So with that, Mr. Canfield.
Thank you, Secretary. Again, very happy to be here. Name is Blake Canfield, Executive Counsel for the department. I do have a slide presentation. Yeah. Yeah, it's showing up here. I don't know if it's...
Try the Windows P thing to project, maybe?
Okay.
Might have switched off. Not yet.
Sure. Am I hidden? What's that? Okay. Well, I guess I'll try to talk to it somewhat, but as we discussed yesterday, protection of the underground sources of drinking water is the primary purpose of the UIC program that we have at DNR. It's based upon the Clean Water Act requirements at the federal level, which the state got primacy for in really a handover earlier this month. Underground sources of drinking water are defined in our regulations as An aquifer or its portion, which supplies any public water system or which contains a sufficient quantity of groundwater to supply a public water system and currently supplies drinking water for human consumption, or contains fewer than 10,000 milligrams per liter total dissolved solids, and which is not an exempted aquifer. So whenever you're looking to try to protect the USDW, of course, one of the main things you have to do is identify the USDW in the area that you are looking to have the project. So we do have very specific data in certain areas of the state and have more general data in others, but basically the responsibility would be on the applicant to go and get data and information to verify the lowest point of the USDW. And that would be what we'd be working to try to protect with any CO2 project.
Click on it again. You need to get up. Click on it.
Yeah, absolutely.
No, you're good.
There we go. Thank you. All right. Yeah, never trust me with the control of the computer. All right. So as mentioned, a large first step in trying to protect the USDW is to define where the USDW is. And so this is a map created by our UIC staff, just showing the general depth, the lowest point of the USDW across the state. The lighter colors, of course, being a shallower depth, and the darker colors being a deeper depth of that USDW. This is the slide I used yesterday, but I think it is important just to give you kind of a general overview, the importance of site characterization, identifying what they call as the area of review. So this would be the limits of the area that has to include all of the information, which would be any and all wells or any other types of penetrations, any structures that are within that area of review. That's going to be based upon a lot of the fact specifics put forth in the project proposal, such as the well construction, the location, of course, the geology, the injection rate and pressure that you plan to operate under, and the volumes of CO2 that you plan to inject. Whenever those are deemed to be satisfactory and a permit to construct occurs, you are then going to be reviewing any revisions to the plans. Again, throughout this entire process, you're gathering more and more data. You're going to revise your site's characterization. That in itself is then going to revise your operations plan, your monitoring plan. You're going to be confirming the background data that's required as being collected, and that you've met the requirements of the permit on the construction side before you're authorized to inject. And then through the life of the operations, you are again, operating, you're reviewing your operations, you're monitoring test data, you're updating your area of review at least once every 5 years. My understanding is that will be more frequent, depending again on the specifics of the project. A larger volume of CO2, for instance, may have a quicker review process. You're going to also be doing any type of permit modifications that would be required. And then, as we discussed, after injection ceases, you again are still doing post-injection, you're doing site monitoring. You're going to be following all the same type of data to make sure that you aren't seeing anything that's unexpected or unplanned. With protection of the underground source of drinking water, you have to identify pathways to the USDW. So you're looking for, as we mentioned, either geologic or man-made potential pathways. This can be faults and fractures that are transmissive of CO2, or could be transmissive of CO2 outside of the storage area or towards the USDW, and could be things like a lack of adequate confining zone. So as I'm going to show in a second, confining zone is going to be very important in trying to make sure that the CO2 does not migrate upwards. It could also be man-made pathways. So this is primarily going to be other wells. And, on the front end and throughout the life, you're going to have to, the operator's going to have to identify any and all wells that penetrate into the USDW. And then make sure that those are not providing any type of pathway for upward migration. And then site characterization, as I mentioned earlier, you're going to be defining the area of interest. You're going to be identifying all these potential pathways. You're going to be mitigating any potential pathway. I think as we talked about yesterday, if you identify a well that's in the area that could potentially pose an issue for a pathway, you are going to have to basically reconstruct the well if necessary to make sure that it's going to be compliant with the requirements, or that you have stopped any potential for upward migration, and that's going to be fed back into the model that you started with, and it will be iterative through the life of the project. Well construction, of course, is very important. We talked about this yesterday, making sure that it's made of the right materials, that you have the right amount of casing and cement, that you are monitoring the well itself, both pressure monitoring, as well as monitoring the actual material, again, for any type of corrosion or other issues that might lead to a loss of well integrity. Monitoring the CO2 plume. So we've talked a little bit about this yesterday. You're going to start off again with your projections based upon the data that you have. That data will then be, more data will then be gathered, and you'll be refining your analysis throughout the operations. You're going to be monitoring not just the CO2 itself, but also the pressure front. So as you're injecting CO2 into the formation, you will see pressure moving out from that injection well in front of any CO2 plumes. So you'd be monitoring both the storage zone itself to see if you see any increase in pressure, or to take samples from that formation. You'll also be monitoring the USDWs in the area to make sure there's no signs of, again, any type of release of the CO2. And then finally, you'll be gathering other geophysical data as you go. So this could be 3D seismic, could be gravity surveys. There are other ways to try to, other than just the wells themselves, to try to determine the location of the plume over time. And then, as I mentioned, just these are some of the terms I've used, so I thought it might be helpful just to be able to give you a visual to show. So the confining layer, of course, is what I mentioned, was of key importance. It's going to sit at the top of your injection zone, and it is going to provide a major impediment for upward migration. You will have multiple strings of casing with cement back to surface, and you will have the injection within the injection zone, or in the injection reservoir. You're going to have the injection zone where you're actually doing the injection. The CO2 that we're talking about is planned to be compressed into a supercritical phase. And I guess the importance here is just to say, as you increase that pressure and it turns supercritical, the CO2 is going to actually act or have physical characteristics or properties of both liquid and gas. And it's going to be injected at a depth to where that geologic formation into which it's injected is going to have enough pressure to maintain it in that supercritical phase. This, I thought, was just a good illustration of what we might be looking at, a kind of a side cut of the subsurface, and how it the CO2 could be trapped underground. So there's essentially, 4 different ways that CO2 can be trapped. Structural trapping, so those are low permeability rocks. That's like the confining layer that I've talked about, which would prevent the upward migration. You could have residual trapping, so it's the CO2 becoming trapped in the tiny pore spaces within the rock itself that you're injecting into. Solution trapping, there will be some of the CO2 which will dissolve into that super salty brine that might be in the formation. And then over time, and this is over like geologic time, very long periods of time, you may end up with mineral trapping, where the CO2 itself will actually react chemically and turn into a rock type formation itself. I mentioned earlier, the wells, the monitoring wells that will be there could be used for monitoring the pressure front of the CO2 plume. You could be taking samples to look at the chemistry for any telltale signs that CO2 is moved into the area. But there also could be geophysical types of surveys that could be run to try to track the location of the plume. And this is just an example that is used by EPA of the North Sea. So the CO2 storage site in the North Sea, where they were able to use 3D seismic to try to track the plume itself. And you can see there the red line, I think, on this is the plume outline in 2001, and then it shows you later in 2006. And this gives you a bit of a sense of the fact that this is a constantly evolving monitoring design system and operational system. So you have you design your monitoring system, you collect monitoring data, you're then going to calibrate your model and then basically do that computational modeling to get more specificity, which will then help you revise your operations, revise your monitoring. And so you're constantly gathering more information and making sure that your monitoring plan is fit for purpose and is going to provide the data that's needed to be an early warning sign for any type of movement of the CO2 outside of the injection zone. And so that's at a very high level, how it's set up within the UIC program, and we're happy to take any questions.
Representative McCormick, you for a question?
Sure. Thank you, guys. I'm glad y'all are back today. Just a couple of quick questions. In your diagram you had there, are you going to be monitoring just the fresh water, or are you going to be monitoring the plume also with those wells?
Correct. So both. You would have monitoring wells into the zone that you are injecting into, and they'd be far enough out to where you're looking for any signs of the plume moving. So you first should see an increase in pressure. So the pressure front's moving, then you know something is pushing behind it. It's going to be the CO2 that's being injected. That could be pushing that. You'll be doing that at that level. Of course, you'll be monitoring the pressure of the well itself.
Will the monitoring wells be used to monitor the fresh water and the plume? They'll just have different set of casings with different set of perforations to do that monitoring through? Correct, sir.
So in addition to monitoring the injection zone, you'd also be monitoring the lowest USDW above the injection zone. And then, a lot of the specifics on this are going to depend on the specifics of the project, but you would be doing both.
When I was looking at your traps there, I noticed you have one of them where it's just trapped up in the top of the structure, not necessarily completely filling up the whole structure. Have y'all thought about are there going to be, I assume that you won't be able to use these particular zones for saltwater disposal zones in the future because you may move the plume with that injection. Is that correct?
Right. So the Commissioner of Conservation, and the UIC program itself also regulate Class 2, saltwater disposal wells also. And so for sure they would not permit anything that would have a negative impact on the Class 6 project. For those purposes.
All right. Thank you, Mr. Vice Chair.
All right. Next, we got Representative Mack for a question.
Appreciate y'all coming back and presenting today. Sort of the same question. I thank y'all for Mr. McCormick asking that question. You explaining how the Class 5 monitoring well is going to have different levels of perforated pipe, being able to check the aquifer. That's good. But I got one question. Initially, are they checking individual water wells, maybe public water wells, private water wells? Initially, in the permitting process, they do that?
So you will have to identify those wells. You have to, that are within the area of review. So I
Right.
think I talked earlier about, based on the specifics of the proposed project, they'll define sort of a geographic limit that would be the area of review. And within that, they're going to have to identify water wells as well as, oil and gas wells or any other type of well. Depending on the location of that water well and if it's, poses a potential problem for upward migration, you essentially, let me rephrase it, depending on this location of it, if it's, would immediately cause some sort of issue, then it very well may be something that, the project would have to get with the landowner or try to work at something out, because you're going to have to, on all of the kind of legacy wells, look at making sure that they're constructed properly and they're not going to cause, any type of issue as far as upward migration goes. And unlike, I think the EPA requirements are that if you have a well that goes through the the confining zone that's above the injection zone, those have to be addressed. The Louisiana rules go above that. So they say, in addition to that, you also have to have any well that goes into that aquifer, the USDW, as well. So it's a little bit more protection than what's required at the EPA level.
And Representative Mack, just to add a little bit, because you asked the question about the difference between a private well. I know that you guys have been listening to conversation around expropriation. That doesn't necessarily apply, right? It's the wells that Mr. Canfield is talking about is any water well. Property rights don't come into it's more about their testing wherever they need to.
Okay, good. Thanks for clarifying. I appreciate y'all so much. So, once again, in the case if an aquifer or private water well was contaminated, how would that be remediated? What would be the plan to resolve that? Would that be in the permitting process for the operator to have a plan to remediate? I've asked that question to some of the operators that have planned projects in my area, and it seems to be they're working on developing a plan. I'm a little concerned about that.
Yeah. So, I guess the fact is that we have these applications that are just now coming over to conservation for review. So they do have to have these response plans in place. And a lot, I guess, of the details, there will be some back and forth on making sure that those plans address these issues. They're likely going to have, an emergency response plan, which of course will have general information and then provide maybe certain scenarios on how they're going to address it. But a lot of times, it's going to be very fact specific. So if you have, if you did have an emergency type situation, they're going to have to look at the specifics of what's happened. If, for instance, they're going to be required to tell the Office of Conservation if the CO2 moves out of the injection zone. It may still be very far away from impacting groundwater. And so from conservation's perspective, that's when they start responding at that stage. And that would not necessarily be the type of scenario that I think you had talked about yesterday, which would be, sort of like a catastrophic, type failure where it got in. The first and foremost, of course, they have to stop injection. They have to immediately go through the list of emergency responders that they have identified as, contacting. Within those emergency response activities, typically, if it affects, the residents, you're going to be looking at some type of state police creating some type of command structure where they're likely going to be the on-scene commander for it, and then our office would be providing assistance, information, guidance, whatever we can to help them out. But a lot of that would be very fact specific.
And when they are going through that process, the reason that I'm making an assumption here, but when you are working to produce a project, there's a financing component to it. And so Mr. Canfield mentioned, there's a ceiling of 5 years that they have to review it. From what we understand, the conversations are being had that they need to have it more often than that. And so when they work through that, that's part of their business and what they're trying to figure out whether or not it's possible, because the insurance and financing component is going to be contingent on that response plan, because that's going to build out their liability. And so that may be one of the last things they deal with from a comprehensive standpoint in that analysis. And so that it's not, I don't think it's an intentional act that they're trying to not answer the question. I think that's probably going to be the biggest final piece of their puzzle.
Appreciate you. That's all I have, Chair. Appreciate you. Or Vice Chair.
Mr.
Thank you, Rep. Mack. Next, we have a question from Representative DeWitt.
Thank you, Mr. Vice Chair. Secretary Gray, thank you again.
Yes, sir.
For coming. And Mr. Blake also, you really have been really informative in all your questions and answers, and really appreciate that. It's really helpful because we have constituents that these questions, we do think of a lot of them, but a lot of them come from our constituents, and we just want to be able to give them an answer, all of us up here. You kind of mentioned something just then, but if I've worked lots of well blowouts over my career and time, and if we have a incident, will we have some type of preparation through that zone, and it's been notified? Who is going to be the agency to be the lead on that?
State police.
State police.
It's likely the agency for an emergency type response. For long-term,
it's going to be long-term,
yeah, longer-term
something like
remediation, then it's going to
Yeah.
be regulated by the Commissioner of Conservation.
Okay, it's going to be y'all. Okay, yeah, because I understand emergency situations and things like that, but typically this may not really be what I'd call an emergency situation when it comes to. Now, if it's a well blowout, that's one thing, but some kind of a failure with the formation or something, whatever that effect is, or we get a hit, let's say on a monitoring well, you guys would be responsible for that.
Yes, correct. Our Commissioner of Conservation within the DNR would be the one with the authority, and I think it's a good point. As I was talking about, it really is going to be kind of fact specific. So the type of monitoring that they're doing is intended to catch not just your catastrophic failures, but of course, if there's a slow leak or something that's, perhaps would be imperceptible without being able to take, those samples and do the, chemical analysis or, something like that, where you're trying to find early warning signs of a bigger problem that could, come, then, I think that is the point, is to address it before it becomes an emergency like you're talking about, or we were talking about with,
Right.
first responders.
Yeah, and I just wanted to make sure who we call and, when that sort of thing. And I've got a few more questions. You were talking about monitoring wells. Do you have somebody with your permitting group here with y'all?
No.
Not today.
Okay.
We could try to answer the questions to the extent we can.
Yeah, if you wouldn't mind, maybe getting back with me, it's fine too, by the way. How often are they actually monitoring? And do they increase their monitoring if they get a plume notification, basically? And are you guys going to be monitoring every now and then, checking to make sure that the company's numbers are meeting your numbers? So can you maybe get back with me on that, talking with somebody in permits, because I'm assuming y'all are just now getting all that going in that direction.
Well, from a high level, I can respond to, so the underground injection control all rests within the Safe Drinking Water Act. Mm-hmm. And from that perspective, that is the primary mission of that program. And so when we're talking about monitoring wells or any sort of potential contamination, it's a very serious issue. And then within the operations of the agency, they take it seriously too, because there's liability for the permittors, right?
Right.
And so, from a monitoring standpoint, that's always going to be our primary goal. So there's no language within the Safe Drinking Water Act that would not allow anyone to require additional monitoring if there was an issue and there were citizens at risk. So just for some peace of mind, just know that there's nothing to impede us from further requiring more data. We can request as much as we want.
So I guess are y'all going to have somebody in your department at least oversee the sampling from? Are you going to use a third party to actually do any kind of sampling I guess you would call it regulatory sampling, basically checking, once a year, once every couple of years, and is that language in the permit to decide whether y'all are or are not going to sample? Because, again, we're talking about the public and them being secure about that site.
So the part of the application process, and this is one of those parts that is going to be updated through the life of the operations, is to come up with a monitoring plan that includes a lot of different types of monitoring. But so some of the specifics are going to be part of that permit review process and decisions, on issuing the permit. They could be conditions put into the permit specific to that plan that would set it out. There are requirements for continuous monitoring of pressures, for instance. There are certain types of parameters where also you're required to have, alarm and shut-off, automatic shut-off systems set up. So that type is going to be continuous. It's then going to be documented. Those documents are to be retained throughout the life of the facility and then some, and are, of course, open to inspection. Specific inspection plans, I guess we would need to talk with our IMD folks just to see what their thinking is, but we do have inspectors and enforcement agents specific to this program. So there would be site visits, but to your specific question, let me get on.
Yeah, I would possibly maybe hire a scientist or two, steal them from DEQ. That'd be a good place, and get them to where they can actually be qualified to take those samples. That work for the department. What that does is give the public security that somebody else is doing it.
Yeah, I know a lot of times you'll have split samples and the like, but to figure out what the game plan is, I want to talk with our folks just so give you correct information.
Right, and like I said, again, it goes back to public confidence in us and y'all. I asked him about location sizes, and he really didn't know of a particular site. I've got two in Rapides Parish that's got applications in. One's in the Forest Service that I found out yesterday. About how big a site generally is a I know what a regular drill site looks like. That's usually 5, 6, 7 acres. Just depends. Is that what we're looking at here also?
Okay.
Well, so when Congress actually created the Safe Drinking Water Act, they actually specifically requested that you consider the geology of the state that it's being enforced in. So, I'll let Mr. Canfield talk more about the specifics, because in Rapides Parish, it depends on the geology, which is part of the charge of the act itself, that defines what it looks like. So if the zone is such that it could be cylindrical, you actually have a smaller geographic area depending on the geology.
Yeah, that's for the subsurface, but on the surface, my understanding is that this would generally be the same size as other injection wells that are out there. But again, we might be able to get some more specificity. I think a lot of the details perhaps could be in the applications themselves. But
because I can promise you, those calls are coming to my office, and I just want to be able to give them an answer.
And if we're talking on the subsurface too, I think one of the things I heard when we were sitting back there under the previous discussion is a lot of times what we're seeing is the companies are going after larger tracts of land and larger leases so they can do some of the site characterization and analysis on the front end to pick, from a geological standpoint, the ideal location for the storage, but also to create a buffer so that they don't run into an issue of, unintentionally the plume moving off-site, underneath someone else's property.
Right.
So when we're talking, size, it's like you have size of the leased area, size of the plume, size of the surface facility. So you have a lot of different variables there. But I'll see if I can, or if we have data that maybe would be helpful in answering those types of questions.
And let's see, if I get a call, how does the public, like if I get a call basically with questions about CCS, is there somebody within y'all's department that is a go-to person?
Yes. And so that's actually where I was going to ask next. When we want to make sure that the answers aren't under the Safe Drinking Water Act, right? Because I know that doesn't help all constituents, right?
Right.
So I mean, we have a public information officer. You can call my office, 342-2710, and we'll connect you with someone to be able to answer those questions. And then also make sure it's in, the people that work on that are actually from northern part of the state and will be able to translate it as necessary.
Okay.
Yes, happy to do that.
I get it. Like I said, that's going to be some of the questions. And is there a whole lot of difference between Central Louisiana and South Louisiana, geology speaking?
Yeah, geologically, there are differences. I'm not even going to pretend to be a geologist. What I've been told is you do have thicker sands in South Louisiana. You may, and again, remember when I was mentioning that they are trying to pressurize for transport purposes of CO2 in this critical state, there is actually depths at which they are looking to inject so that it maintains the pressure at depth to keep it in that supercritical state. And so that does limit somewhat which sands you can consider, which types of formations you could consider from a reservoir, for a zone to inject in. But what I've been told, so a huge grain of salt here, is that essentially in South Louisiana, you may have multiple layers of these thicker sands that would allow for sort of what the Secretary was talking about, where you could have injection occurring in several different zones. And that theoretically would allow you to store a larger amount of CO2 in a relatively shorter or smaller, footprint, below surface. But that same geology doesn't exist the further north you go. So my understanding is that you'd be looking at maybe fewer of those zones being stacked at that depth that you need, and you could end up having, when you're injecting more to within one zone, and so it would go out further. Basically, you could have a larger surface area underground that would be covered by that.
I got you. Any idea where our main aquifer is up there as far as depth-wise?
No, but we can get that for you.
Yeah, that's questions coming. I see that coming. But I think that's it. Let me make sure.
And Representative DeWitt, I just want to let you know that there's no other place I'd rather be than right here answering y'all's questions. So happy to be here.
Yeah, and look, I think I speak for everyone. These questions are coming, and I just know that we'll need to be able to reach out to someone in your office, and thank you for giving us that information.
Yeah, absolutely.
Of who we need to talk to. The only other thing, my colleagues had mentioned something about landowners' compensation. How will that be done between small landowners versus a larger landowner? Is the department maybe looking at that, maybe coming up with some type of formula versus these companies where the folks don't think they're getting taken down the road, so to speak?
Well, so, right now, I think as was mentioned, there is no unitization authority for our Office of Conservation to kind of work that out. So currently it is done, via contract between the companies and the landowners. Y'all did hear a good bit more than I heard about the expropriation process, but that's how it's currently set up. In the event that unitization authority were given to the commissioner, typically they may set the ground rules on how that compensation could be determined. And it's I can tell you how it's currently done on the oil and gas side, but that's not necessarily how it would be done on carbon sequestration. But oftentimes the commissioner is going to figure out how you allocate the production amongst the landowners and mineral owners that are pooled within a unit. But the actual, value that's going to be given is going to be dependent upon the value of the oil or the gas that's being sold, and then allocated back if it's under a lease. If that area is under lease, then of course the lease would decide the actual royalty payments. If it's not, then that's when you get into deducting costs, and it's going to be once the well's reached payout. You then would have production, value of the production going back to the individual mineral owners based on the allocation principles the commissioner sets.
Right. Is that part of the permit process?
No, so not now.
What they paying landowner, is that
no,
part
not
of the
at all.
application?
Not currently.
What about appeals process if these, is it Last thing we want to do is have to go to court every time. Is there something y'all may want to consider with y'all's department possibly getting involved unless, what do y'all think? What's y'all's opinion on it?
Well, we don't love, I'm just gonna be honest, we don't love dealing with expropriation issues either, right?
Yeah.
And so I can tell you from what I understand, the way the other states operate, North Dakota, Wyoming, there is a unitization process. They have some steps that they take to ensure that there's equity across different landowners. I know that there are industry user groups that are currently crafting something, but it may end up being something that's a combination of both, right? Because you have to have some expropriation authority around the pipeline, and there's a process there. But the unitization could be a more of an administrative path in order to talk about what those ownership rights would look like. And just listening to the dialogue here today, it's something that we can go back and reevaluate.
And like I say, possibly pull from Wyoming or North Dakota, possibly even those areas, because I can tell you when you go to expropriating somebody's property, they're not happy already. So I would want to make sure that whatever process is in play, that they think they get a fair shake. That's all.
Absolutely.
Well, thank you, Mr. Co-Chair, Vice Chair.
Thank you, Representative DeWitt, for a very comprehensive questioning session. All righty, next we have Representative Coates for equally concise and cogent. Sorry, there you go.
Turned on, okay. Welcome back, guys, thank you. So, question, because we've been talking about the plume moving and getting under other people's property and stuff. So once a company signs the certificate of completion, who checks the plume? And
So
how
you're talking about after the injection operations have been completed?
Yes.
Let me rephrase it. They're going to be required to continue to monitor. So the stage that you're talking about is when essentially it's been determined that the site can be closed. So it'll be monitored up. So like after injection, you then have this monitoring period that continues, and that could be sort of the default's 50 years after injection. So during that time period, you're still looking to the operator to continue to monitor. The point after that monitoring is done is when there's been a determination that the site can be closed, the monitoring can be stopped. So that would be the plan.
So is it, and I'm sorry I didn't look at this beforehand, but is it set in statute that is 50 years? Or in the regulation?
Yeah, so in the regulations, this is similar to, and my memory was they basically copied this from the EPA, but I'll have to go back and look. So the default time period is 50 years after injection has ceased. It allows for an applicant to request a shorter time. It allows for the commissioner to require a longer time if they've been unable to essentially prove that the CO2 is going to remain in place within that zone, is not showing, like movement of any significant amount, and it's able to be closed off.
But try to, because when you're asking who checks the plume, those are what the monitoring wells are used for too, because they look at this, whatever that content would be mixed into the, whatever the sand is, they're trying to track where that is and how it's moving. If the concentration increases, that means the plume is moving that direction. So they are always looking at it. Mr. Canfield was going through a lot of the timeline after it. I just want to make sure we're answering. It's a combination of both.
So I guess I wanted to say, all right, if the company shuts off, they're not injecting anymore, and they sign saying they're done, who is monitoring the plume after that injection stops and for how long?
Right. So the company's required to continue to monitor after the injection stops. 50 years is the default. It could be longer. It theoretically could be shorter in time. But again, they would basically have to show that the movement has stopped, the plume, that it's expected to remain in place. So that's the only time you would look at stopping monitoring. But so long as monitoring is going on, you would be looking to the operator to continue that monitoring. There is this fund that's been set up in the event that, a company disappears, bankruptcy, whatever. There you would have to have the state contracting for workers to go out and do that monitoring and that type of post-injection work.
Well, that was my next question. But so so if the 50 years is done, when does the 10-year of the liability kick in? If that makes sense.
Yeah, so they essentially changed it with the language last session. So it's 50 years or as otherwise approved under the regulations. And at that point in time, you have that when it's basically determined that the plume stopped moving, it's going to remain in place, and then that certificate is issued. It's upon issuance of the certificate that the liability for the operator goes away.
Okay. Thank you, Mr. Chairman.
And just a quick, it's 50 years for the plume stability. So that's the period. Just you have to have stability for 50 years before they would even talk about going to that next stage for a release.
Okay. Thank you.
Yes.
All right, and last to clear the board alphabetically and coincidentally would be Representative Zarang.
Storia. Mr. Secretary, Blake, thank you all for being here.
Thank you.
Just a quick question. In regard to the carbon and the issue in terms of aquifers or drinking water, it's primarily not so much the carbon itself, but the impurities associated with it for the most part, I would assume, that over time. The Class 2 wells for injection fluids are monitored. Those are Class 2 wells, and carbon are Class 6 wells, right? So the difference, obviously, is in terms of both the monitoring requirements and others. But has there ever been a major failure? We've been injecting fluids, all field fluids, in the Class 2 permits for a long time. Has there been a major breach or failure on one of those that y'all have identified or heard of?
So there has been the one there was one in 2012. That was a Class 3 well.
Yeah, so the brining was...
where they're mining the salt.
Okay.
That was where they ended up mining too close to the rock, and so the solution was allowed to get out of the cavern. But more towards the the salt water disposal, they've been re-injecting salt water back into zones following oil and gas exploration since 1929. And then you had two incidents in the 60s and 74 that sparked the Safe Water Drinking Act. And so those were not even in Louisiana. And since then, it's been pretty heavily regulated.
So it's heavily regulated. And even the CO2 will be to an even greater degree in terms of what we previously do for other wells.
Yeah, so and I think the EPA has said this, that it is the most comprehensive and stringent requirements for any injection wells are these Class 6 wells. I know the initial rulemaking started with the Class 1 hazardous waste rules as the starting point, and then they modified it for CO2. So it is a very stringent, regulatory scheme. Yeah.
Good deal. Thank you, guys. Thank you, Mr. Chairman. And Mr. Vice Chair.
Thank you, Representative Zarang. The board is clear for y'all. If we could have Scott. Is it Eustace?
Eustace, sir.
Eustace? All right. Okay, members, we are going to allow questions as soon as they present as well, but would ask that you keep them as short as you can. We need to get the next person to testify up here pretty quick because he traveled from Mississippi and has been waiting quite some time. So be respectful for that as you ask your questions, please. When you're ready, sir, if you would identify yourself for the record, and then we're ready when you are.
Hello, my name is Scott Eustace. I'm the Community Science Director for Healthy Gulf, and I've been a coastal wetland specialist with that 28-year-old organization for more than a decade, concerned about water resources, including wetlands. The grandson of a geologist who drilled in Terrebonne and Plaquemine. And I will Control K. Came with slides to talk about impacts to the land, to the water. I think what we're not discussing, the committee's not hearing, is the scale of the projects. And we're contemplating a much larger scale than we did in the clean coal era. You'll notice a lot of the laws were written in 2008. EPA regulations around impurities in the pipeline were written for coal flume instead of petrochemicals. But the scale of the new 45Q tax credit is much, much larger, and we're talking big. You know, and the questions about how large is relevant, and we hear many different things from different geologists. You know, when Exxon is leasing the ocean, they're leasing about 500,000 acres off of Galveston Island. So that's why I think you see a lot of leases in timberlands. And an unfortunate thing with this increase in the tax credit is we think that, you know, our wetland properties are of low value per acre, and it's very simple for a landowner to convert that to industrial real estate and make a profit without considering impacts to the water wells, to the wetlands. When it goes right, there's a lot of this, cypress trees coming down, and this is bayou corn. When it goes wrong, even more impacts to wetlands. If a project is started and then stopped, as most in the clean coal era, 90% of the tax incentives were taken back by Treasury, as I understand it, or at least they either lost the carbon dioxide, they couldn't account for it for Treasury, or the project was never economical to start. But if we start projects, we're going to be digging up trees and then having nothing left to show for it. You know, when I went to college, you know, my grandfather said, you know, hey, go study biology. I know where all of this wreckage is out there in Plaquemines Parish. We could fix it. I'll be the petroleum engineer. You be the biologist. We could start a company restoring the coast. That never happened, right? We've got 400 square miles of coast that we don't have because, you know, we passed good coastal regulations, but when enforcement came, it was not feasible. And we fear a similar pattern when we look at carbon injection at this scale, and especially when we're going back to the coast, when in the clean coal era, Denbury avoided the coast. So these are the migration pathways for a plume. These geologists I borrowed this slide from, you know, have the plume crossing old oil wells, which are deeper than the Class 6 formations. CO2 can also migrate through seismic faults or an interaction between old oil wells and seismic faults. And when we look at the well population we have in Louisiana, we have a lot of uneconomic wells, over 28,000 wells not producing. I think the first presentation said a portal to hell. You know, at least that's a 10,000-foot hole into the underworld. And what happens underneath there changes. Wells depressurize, repressurize. Some of the issues we have, I know of several active hazardous materials problems out in Plaquemines Parish right now where I was the monitor for combustible gases coming out from under the earth. It's not, and so we don't have a lot of confidence given that the industry has left a lot of wreckage across the state, that some of these longer term, 10-year, 50-year obligations will be met. And the scales that we're reading about in the geological literature are much larger than what's been discussed. So it's expensive any way you move. You've got billions of dollars in idle wells that need to be plugged. We need to hire hands to get out there and cement the wells. We've got billions of dollars of wetlands damages that we could be contemplating. A whole new coastal restoration program might be having to be considered. And then the drinking water. So the companies are saying different things about the risks of these existing wells. What you see is the more well-heeled company like Conoco and Exxon are going into the wildlife areas. Air Products says, well, we can't inject next to our refinery in Ascension Parish because the seismic and the borehole issues are too severe. Therefore, we have to run a 60-mile pipeline into an area where that's been protected from drilling, because that's the only place Air Products felt confident enough that their plume would stay stable. This is an application from Conoco, and we did oppose it because it was in Des Allemands. That's where we eat our catfish from. Again, they were seeking to leverage this. It wasn't a small property, but it was just in the 3 digits, the hundreds of acres on Des Allemands, what we eat from. This is their alternatives analysis, the polygons on the map. They're trying to find areas where they could put a plume that isn't penetrated by these wells that would be leakage vectors. And so you see that Conoco wanted to inject in the Scenic River area, Denbury into the federal Mr. Go project. Exxon was seeking to lease White Lake in addition to their sizable holdings in Vermilion. And Air Products said, we have to go into the wetlands because there's too much junk out there interfering with our ability to have a successful project. And they're interfering with the Maurepas Swamp Restoration Project. So again, is that $300 million? It's a large expense that the state is putting forward to have Air Products interfere with it. All for something where ultimately in the past, we couldn't account for the CO2 and Treasury took the money back. When it goes right, it looks bad. This is Sorrento Dome. This is Class 2. I think there might be a Class 3 maybe, but this is mostly a Class 2 injection site off of I-10 north of Sorrento. And here we have Exxon Shell Plains. Injection fields, when we look at them from a wetlands perspective, they look like this: 20-odd wells, a lot of roads, and a lot of dead trees and a bunch of nothing. There's T-norm probably out in the swamps that are now open water that used to be forest. This one's about 600 acres. I would look at Bayou Corn, like the good part of Bayou Corn, even the good part of Bayou Corn. There's about 100 acres of wetlands lost just from these roads and the paths, right? It scales up, and we're looking at 40 projects across the coast. You start to get into the 4 and 5 figures of coastal wetlands damage. The borehole risk, if you believe Air Products, we have to. That creates a scramble. You have a lot of places with above 100 existing penetrations in the 5-mile radius. And, we were just, I'm a biologist and a mathematical statistician. I'm not a geologist by training, but I just looked in the literature for the Petra Nova project. They had an area of monitoring larger than the area of review because the area of review was statutorily or defined by guidance as too small. They wanted a larger area. So they picked an MMA, which I think they made that acronym up, but a maximum monitoring area of 5 miles for the Petra Nova Enhanced Oil Recovery Project. So we look at that project, which is on the salt dome geology of the Texas coast, as analogous to if we're going back into the wetlands to inject waste when we've got a lot of unfinished business from my grandfather's day. We created this map just to look at some of the alternatives, and there's different companies say different things. Air Products is in Lake Maurepas there. You might only have a couple of wells. They said they have 63, and that was more than we found. So they're looking at larger than a 5-mile radius as the area of review. And in some places you have 500, 600. I think off of Grand Isle for Cox Operating, it's nearly 900 wells that need to be at least looked at. The geologists tell me if it was plugged before API standards in 1974, you really probably want to just replug that because you don't know what the cement has done. There's been changes in the pressures. It was plugged before there were cement standards. So those vectors, things that were plugged before 1974, need to be probably re-drilled by every applicant. And the scale of that is enormous. 5,000 wells may not it seems like a lot to me. I mean, the industry-wide in the state, we drill about 1,000, or I think we plug 1,000 a year. So when our organization expresses skepticism of the capacity of the department, which has no drillers on staff, they can't go out and remediate some of these active methane emergencies that I ended up having to report. It's just more wells. That's about 5 years of work, industry-wide. If the department had to deal with these, it would be much longer. So, it doesn't seem to comport that, if it's going to take 5 years to secure these leak sources, but we're going to be issuing permits probably faster than that. Probably the applicants are going to want to see their permits issued in, less than 5 years, I would guess. So it seems predictable that we'd go through a permitting process, and if the department actually holds to their standards, there's going to be complaints, right? And the industry would come to you to lower those standards. And we've seen that. It's Louisiana. So again, the scramble, air products, injecting where we ban drilling. Why don't we do it like they did in clean coal, where they inject on their plantation in Orange Grove, right? That would be the logical thing. But again, this applicant has said, we have to build a 60-mile pipeline. They've even leased a lot of the WMA a lot closer to their plantation. But they said we have to get 60 miles away from the river because the seismic issues are too great and the existing well population is too large. So that means that's the cost of wetlands. I review the 404 permits. In the New Orleans district, petrochemical pipelines are the #1 cause of wetlands loss. That's the biggest reason we tear down our swamps and forests. This proposal would be, it's a slightly different geography than this map now, but the current geography is 689 acres of wetland forest. A lot of that is swamp. We've had a lot of problems mitigating swamp in this area. The forest is not coming back when we cut the trees down. But if you just put $50,000 on that, assuming it is possible, $34 million replacement just from those 5 miles. And you're interfering with a project we've spent hundreds of millions of dollars to plan. We get some federal money, a lot of it is state money. I think we're using BP settlement monies. So it's unacceptable. I think we've been in this right-of-way so many times. There are 21 pipelines in this right-of-way, and the agencies like to reuse that right-of-way. 21 active, I don't know how many inactive in this right-of-way, including 2 that we wanted better review for because Shell connected its Norco and Convent refineries. It said we have to destroy 600 acres of cypress to connect our refineries to save the Convent refinery. Under the regulations, they, were supposed to give us 10 years guarantee of labor and benefits, and they did not do that. The department did not push for it, and then the Convent refinery closed. So those pipelines are inactive as far as I know. There's certainly no need to put vacuum gas oil into Convent anymore. So we're concerned, given the history of these 45Q, that most of it is clawed back because it's ineffective, that we're going to rip up a lot of things that we can't replace. The mitigation for that Shell pipeline, 2 of the 3 pipelines are dead, but the mitigation is failing. So that's very sad because we need those forests to stand to mitigate damages to Santamont, to Prairieville, and to Baton Rouge even. And this is the reversal. We got the new 45Q, much, much larger than even what University of Houston asked for. Probably because it was for the sake of coal burning and not this. But, too much red on this map is below I-10. And compare that to where the CO2 industry was in 2007, that Denbury pipeline, the existing pipeline, the brown line, you see how it's north. And it cuts back down into Donaldsonville and then heads back up through Livingston. But for the most part, there's very little footprint of this pipeline in the coastal zone. A bunch in the coastal area, as we say, but they put it away from the hurricane and away from where we as residents have to evacuate from the hurricane. So it's distressing, that the policies have shifted. We feel that's because the size of the tax credit is making this into a real estate issue rather than an engineering problem. And Great Plains Institute, this is a CCS advocacy group, and they're not from Louisiana, so I don't know how the committee takes that, but they're very for this technology being implemented in the West and Illinois, but they've said that, you might want to be careful and not do it in these places in red. 90th percentile for, again, the Mr. Go restoration project that Denbury has leased the minerals from the Biloxi Marsh Company. These engineers and geologists from the West say, you might not want to do it there. Plaquemines LNG site in the red. Vermilion Parish Exxon site in the red. And this isn't even considering engineering. This is merely on environmental values. And we're largely talking about wetlands, food, endangered species. So, you've got $1 billion of wells to plug. We've got billions of dollars in wetlands damage that could happen that we don't want. And then there's a little bit about drinking water. When Petronova, 5 miles, again, they had to define, and the agency said, well, we can make them go as far out as we want. The Texas legislature, I think, in law, they defined the area of review as 2 miles, and the geologists felt, well, we need to go 5 miles, so they called it an MMA. And there was a paper at the time, again, in the salt dome geology. So this kind of paper, which is coastal Texas, does not apply to Vernon or Caldwell, but in the salt dome geology, the geologist at the University of Texas, Austin, found a zone of 20 kilometers kind of uphill, perpendicular to the faults. 20 kilometers, and they named that a zone of zone of endangering influence. So this is if these CO2 the saline formations, they do probably have some relief to them and a pocket, and I guess it's contemplating that the layer goes closer to the surface in a particular direction. In Texas, their coast is, the direction would be to the northwest. For Louisiana, at least in the coastal area and coastal zone, our faults, our geology that's like this, it would be more of in a northerly direction. So the scale of these areas of review seems to be larger than what we're hearing from the agency or from EPA or from anybody. I have some geologists telling me it's even bigger, but this is the publication, this is the geology out of Texas I find. I really encourage the committee to look at how many landowners are within 20 kilometers of injection, and we're working with some former EPA staff to try to quantify that, and we would love to give that to the committee. Again, I don't. So this zone of influence, 20 kilometers, smaller than.
Scott, let me interrupt you for 1 second. We are pushing up on our time boundaries,
yes, sir.
and I do have
done.
questions. So if you could try to get to your closing, and remember we're information only, so kind of keep it down the middle. Thank you.
Yes, sir. Well, the committee, we really advise them to look into the zone of endangering influence literature. This is kind of how we imagine the map of that looking for the 40 injection sites. Again, this paper probably doesn't apply to Caldwell or Vernon parishes, but most of the projects are south of I-10. So we do think that 20-kilometer zone is something to consider if, there's a lot of landowners, many of them not going to have the capacity to hire attorneys or geologists. We know the history of this tax credit is that most of it was clawed back because we lost it. And then there's the duration to consider, that this is supposed to be immobile for a long time, and we're concerned that we lack the capacity to model it. Any one of these problems is on the billions of dollars. If it's 5,000 wells that need to be plugged, 5,000 acres of cypress forest that we're really struggling to replace at all, or replacement value for drinking water wells. These are very large scale problems, so thank you for considering the scale of these questions.
Will you take questions?
Oh, yes, sir.
I didn't know you were through. I'm sorry. Let me change your mic 1 second.
Speed it up.
Okay. And thank you for that presentation. Vice Chair Orgeron for a question.
Thank you, Mr. Chair. Thank you, Mr. Eustace. Your passion for the coast is clear and obvious. A couple of things you said that I want to clarify. Shale, pipeline, unused, mitigation didn't turn out the way, it's like you kind of made it like they proposed mitigation and it hasn't come to fruition. And I'm pretty close to shale, and it doesn't seem like that's something that they would let stand like that. So which mitigation area were they working on that you were referring to?
Yeah, this is coastal permit 2014-16, 3 pipelines through the Maurepas Basin, and the department, I believe, is going back and forth with them. You're right, Shell has some money. I believe the liabilities aren't with Shell; they're with a different company, but they're trying to work it out. But what was planned, their 5-year review. What's in the language? They didn't hit their 5-year target, so it's an ongoing problem, and
But they're not walking away from it. They're still working on it to get it properly mitigated.
Right.
The other thing is on the what I'm going to call the Louisiana Red Map.
Yes.
That was Great Plains that had done that work, and the redder density was just based on the density of boreholes in the area with a direct.
This was just based on social and environmental factors.
Gotcha.
So the amount of wetlands, natural resources, things like food and fiber, as well as human residents, and there are different resilience indices that they used, which has to do with the ability of people to evacuate or return. So that wasn't an engineering evaluation.
Also, representing District 54, I represent the people of Des Allemands, but not where Conoco's project was. It was my understanding that they were just going for like an appraisal well. Was that the situation?
Yes, of course. Even the appraisal is damage, but there was a coastal use permit application for a Class 5 that was then withdrawn. So Conoco's statement was that they decided not to pursue that area. We know that they are looking at a different site in Cameron Parish.
But that was an effort on your organization's part to squash their activities, even though they were just looking precursory to see what they had under their own property.
Yeah, well, again, 50 acres of wetlands forest is very precious. So that is something of concern to us. I think the residents' concern had to do more with the fisheries business. So together we did call for a hearing, and Conoco just withdrew the application. So we didn't even get to hear the hearing.
My understanding was that their prospective plume or the area of appraisal was completely within the bounds of their own property.
My understanding is that that's why you do the Class 5 well, to figure that out, to figure out the depth of the formation, but I could be corrected.
Well, we talked a lot about eminent domain, and a lot of people here are passionate about private property rights or property rights. So I was a little concerned at how Healthy Gulf had injected itself into that, at the time that they were just looking for appraisal on their own property. But I understand your passion and concern, but you understand the little bit of a hypocrisy there that they're just looking at their own property and seeing what they have underneath it, and it was a little bit of a stop. So, but I appreciate the information you provided to the committee. Thank you.
Thank you, Vice Chair Orgeron. Mr. Eustace, there are no further questions, and we do appreciate your patience waiting to testify and present to us, and we appreciate all the information. So that's it. Thank you very much.
Thank you.
All righty. All right, next up is going to be, we are now on emergency preparedness. We're going to ask Mr. Jerry Briggs from Warren County, Mississippi Fire to come and do a presentation on an incident they had in Mississippi. Before we get to that, next will be public comment. If you want to comment, you need to fill out one of these white cards. And then based on the amount of cards we have and the time remaining, we may have to implement a time limit on that. So if you have not filled out a white card and you wish to speak after this presentation, please fill one out. All right, identify yourself for the record, please, and thanks for being here.
Yes, sir. Thank y'all for having me. Jerry Briggs, Fire Chief, EMS Chief, 911 Chief, Warren County, Mississippi. And probably by the time I get back, it'll be another something attached to the back of my name. But I'm here just to talk to you about some preparedness things with what we experienced in Satarsa, Mississippi, or Yazoo County. I think it was a little over 4 years ago now, with a pipeline rupture that we had of carbon dioxide. And basically, to kind of keep it short and everybody's ready to go, we were called by a neighboring county in Yazoo, one of my counterparts up there, that they had some type of release. They kept referring to it as an explosion, a rupture. Didn't know what it was. They knew they had chlorine in the area. They knew they had natural gas. They knew they had all kind of things. They were unaware that they had carbon dioxide. And this is the Office of Emergency Management in that county. So we were asked to come up there and help. The town that it affected, I think the actual number of residents were probably 50. Households probably in the 20 to 30 range. And when we got on scene, it took my group, I took 4 guys with me. It took us probably 45 minutes to respond there. We were probably an hour into the rupture by the time I made it to their original checkpoint. And at that time, they still did not have an identity of what was leaking. They knew that they had people in the middle of the highway, unresponsive, had abandoned their vehicles, laying out in the roadway. Same thing at residences that were out grilling or doing their thing on a Friday night, and got overcome and were just convulsing. When I arrived at the checkpoint on the main highway, I did observe several people laying there that had been brought in by other passerbys in the area that were on their side, vomiting and unresponsive. So at that point, we, again, still didn't know what we had in the area. So me and my team loaded all of our protective equipment up into a side-by-side or UTV and proceeded into the blast area or the community. We had Mr. Jack Willingham, which is our emergency operations guy for Yazoo, get in contact with the Weather Service for some plume modeling to see where whatever this is may be going. The Weather Service kind of gave us a plume. He relayed that to me. Appeared the plume went directly over the small town. So we went door to door, checking every house, every car in that town. And before we left, there was one other area that he wanted us to check that was probably within a quarter mile, half a mile of the actual rupture. And we found 3 unresponsive males in a car that were probably close to death as you could get without being dead. We noticed problems going in. Our side-by-side wouldn't run, so most of our stuff was on foot for the duration of it. We encountered these guys. I sent our driver out with the side-by-side to keep it running while we extracted all of them from the car, loaded all of those guys up, and took them back the 5 miles back to waiting ambulances. The reason we were so far away is our emergency vehicles wouldn't run out there because of the lack of oxygen. Later, we did find out it was carbon dioxide, and really didn't change how we would approach anything as far as a response thing. Had I known it was carbon dioxide in the area, I probably wouldn't have wore all that structural firefighting gear. I'd have probably just wore some type of breathing apparatus and been a whole lot more comfortable walking around for the 4 hours that we walked. So, you know, I've been here before talking to some of your fire chiefs in your outlying communities. I think your people are prepared for this type of response. As far as what they have currently to fight a structure fire, they're going to be breathing their own air, that kind of thing. I think where the problem lies is they don't know what's in their own community. After that event, I visited the blast site, ran across a guy. I'd actually stole his stuff out of his truck because he had air monitor stuff in his truck, and I didn't realize he was anywhere around. And I made the comment to him, asked him what it was, told me. And I said, well, thank God this doesn't run through my county. And he said, well, what county is that? And I told him it was Warren. He said, oh, yeah, we run straight through there. I've been doing this for 28 years, been a fire chief for probably close to 15 years, worked for the county for 12. Never knew this pipeline existed. I knew where our natural gas pipelines were. I knew where other pipelines in the area were. We'd never had any communication with this particular company. Now, since the explosion, we have great communication with this company and offered trainings and equipment and that kind of thing. So the biggest thing your people are going to have that they probably don't have is manpower, because most of these events, most of these pipelines are in very rural areas for that reason, right? Safety of the public, you don't want them going next to a school. But what comes in rural areas is rural money, and rural money gets you rural resources. And you don't have much other. I know one of the fire chiefs I spoke to just south of here, we were talking, and I asked him, I said, you know, if a car wreck come out right now and you had trapped people in the car, I said, how many people can you count on? He said, me. So that's for a car wreck. When we're talking about a pipeline explosion and you're trying to evacuate people. You can't depend on these pipeline companies to come in and save you. Yes, they'll come in and try to fix their leak 3 hours later, 4 hours later. So you're kind of on your own until that leak is stopped. From my understanding, they had our leak stopped within an hour. However, it was close to 4 hours before it stopped leaking, just from the residual pressure between the valves. So basically here to answer any questions that y'all may have of emergency response. The biggest thing that I can tell you about our pipeline, you have several phases. Seeing me there and my stuff is not a good day for you. But if you on the front end can get the laws in place and the enforcement in place, you'll never see me. The pipeline that we had 5, I think, critical failures with PHMSA. That's what they were fined for. So making laws and doing all those things are great if you have somebody enforce them. You know, you can make the speed limit whatever you want to on your street, but if you don't see a cop, pretty sure we're not going to go that speed limit. So I think that's our biggest thing is who enforces this. I know you can set the policies, set them however you want them, but you're not going to go out there and make sure they're following it, right? So that's where we're at with this, is who's going to be the one. And I heard all the eminent domain and the infringement on other people's property, but who's going to go tell these people that it did? Obviously, not somebody's going to write a check to them. You know, that's going to be the last person to want to tell them. So as long as I don't know, they're not going to just pay me. So that's what I urge you to figure out is how do you enforce the law that you already have?
Thank you very much for that. Oh, you will take a question?
Sure.
Okay. Representative McCormick for a question.
Thanks, sir. Sure do appreciate you making the drive. That's quite a sacrifice, and we do appreciate that. All the knowledge we can gather, we sure need. I guess my understanding, maybe you can enlighten me on this, when you have a CO2 leak, the CO2 is heavy, and seems to stay closer to the ground level than maybe with a natural gas leak that would disperse quicker. Is that correct?
That's very true. Natural gas is lighter than air and it will rise.
Right.
And CO2 is heavier and will sink.
Do y'all have CO2 monitors that you can wear that now? I know they have H2S monitors. I didn't know if your responders had CO2 monitors. I don't even know if they exist.
They do exist. What you're actually measuring is oxygen in the air.
Okay.
You're not actually measuring the CO2.
Okay.
And that's where CO2 displaces oxygen. For an example that I would give you, I hear this all the time, CO2 is not harmful. So what we expel when we breathe is CO2. I understand it's in your soda or whatever that you drink, but it's also what you expel. So just for that person that says it's not harmful, put a paper bag over your head and breathe a little while. And when you wake up, tell me how that worked out for you.
I got it. Anytime the concentration was enough to keep your side-by-sides running, did y'all have breathing gear on that day?
From the time we left the checkpoint, we were in breathing gear.
Okay.
We did hot swaps. For what that is our personal bottles had to be changed while you held your breath.
Did y'all have any fatalities that day in the public?
We did not.
Did not. That's fortunate, isn't it?
Very fortunate.
I know from growing up in a rural area when the heaters in houses, my wife when she was young, had experience with CO2 in the house, and it's quite devastating. But
that may have been carbon monoxide.
Okay.
Not carbon dioxide.
Okay, I got you.
Heater.
It was still devastating.
Yes.
But.
It's just carbon.
It's carbon. What do your fire districts in your area collect ad valorem tax off these pipelines, or do they give them property tax abatements, or do you know?
I don't know about the abatement. That would be way above me. But the current pipelines that run through, the current CO2 pipeline that runs through does not run through any of my fire districts that are taxpaying.
So even though you're the responder, you're not in your district per se.
Right. And my response area not in my tax or my fire protection district, which is a tax.
Okay, I got you. Well, thank you very much. I sure do appreciate you making the trip.
Yes, sir.
Sorry, Mr. McCord.
You made me feel like I was at home.
All right. We also have at the table to help answer questions from DNR. You want to go ahead and read? State your name for the record, please.
Steve.
I got you. Wait, hold on. You turn it off? Now you're on.
Okay, thank you. Stephen Gimbroni, Pipeline Division Director for the Office of Conservation. I can answer any questions you have about pipeline operators' responsibilities concerning emergency response.
Okay. Do you have any opening comments, or you just want to take questions?
I can take any questions that you have.
Okay. So, members, you can ask questions of both of these gentlemen. Next up, Representative Coates for a question.
Thank you for being here. We appreciate you coming down. The emergency response has been a lot of questions in the community and stuff, and knowing what happened and how it happened. And it has been said many times, carbon dioxide is not poisonous and it does not hurt anyone. Is there still people in the community that you know of that are still suffering from any effects of this?
I do know that the three gentlemen we pulled out that were severely sick, I think we ended up pulling out total that night, maybe pushing 20. Not necessarily from that community, but we ended up following the plume model further out just to make sure, and that's kind of how we knew our search area was from that plume model. So we weren't just searching in the middle of nowhere. So we searched some other houses and pulled some other people out that weren't nearly as sick as those three individuals. But I've actually kept in touch with one of the individuals, and he's still having some problems.
Okay, that's unfortunate. I know we're in Louisiana, you're in Mississippi, but I guess maybe in your experience over time, how would you think as an emergency responder this type of thing happening on water? Over water, like in a lake, and having to respond to people?
I'm not sure your question, if it happened over water, or the people.
So if you got boaters out there that needs to
Right.
go be rescued, what do you do?
I think the disbursement of the plume would be greatly different. The reason we had the problems that we had is they were kind of trapped where they were in their vehicle.
Mhm.
And it was kind of in there with them. And maybe if it was in the open field or water, then it may be different.
So the other 20-something people, I guess, where were you finding those? Like in their homes?
In their homes, yes, or in their vehicles.
Mhm.
And the biggest thing with those people is their vehicles were dying in the highway.
Mm.
And they were sitting in the vehicle, not knowing what's going on, trying to get the vehicle to crank. And, it was a large saturation initially, and then it got better, over time after the valves were cut off.
But if motors are quitting working, and they're trapped out in the middle of a lake.
Yeah, you would have the same effect.
Okay. Thank you again for being here. Appreciate it.
Yes, ma'am.
Thank you, Representative Coates. Representative Mack for a question.
Just want to thank you for your service and thank you for coming here and presenting, giving your testimony. Just a couple of things. I heard you say that you were tracking the cloud. Do you happen to recall how fast the cloud was moving, at what speed maybe the cloud would be moving through the area?
I don't. I wasn't personally doing it. I was just getting updates on the radio of where it was. They were sitting somewhere in an office telling me, go this way, go that way. I don't remember a speed or whatever. And there's a reference to a cloud just for a responder side. I never seen anything.
Oh, really?
I never seen a cloud. I never seen any white gas or green gas or anything like that.
So it wasn't visible?
Not to me. That was the early reports that we had from the public, that it was a green gas, and that's kind of why we were thinking chlorine or something like that.
Mm-hmm.
But I never physically seen any change in the atmosphere.
Well, my next question was, could you see the cloud, how big the cloud was, but you answered that, so I appreciate that.
Yes, sir.
That's all I have, Mr. Chair.
Thank
Once
you,
again, thanks for
Representative
coming.
Mack. Vice Chair Orgeron for a question.
First of all, thank you very much for your service. Mr. Stephen Gembroni, the question about the pipeline, and I think yesterday we had heard about carbon dioxide being corrosive, and are you familiar with that pipeline breach? And kind of like in Louisiana, what are we doing to make sure that incident doesn't happen here with going forward?
I am familiar with the incident. I'm familiar with the pipeline. That pipeline is a part of an interstate system that runs through Louisiana. And so as he mentioned, that PHMSA regulates that line, they regulate the portion line also in Louisiana, and it also goes into Texas. And so PHMSA regulates that entire system through their inspection program. So we don't regulate that line.
Okay.
We have a pipeline safety program. We don't currently have any intrastate CO2 lines here in Louisiana. So we don't necessarily have inspections occurring on those types of lines right now, but should they be constructed, we would regulate those under the same federal safety standards that the feds have adopted and that we have adopted as part of our program.
Thank you. Sir, your name again? I apologize.
Jerry Briggs.
Jerry. Mr. Briggs, thank you. Or have you gotten any assurances from the pipeline operator that this issue won't be happening, or any remedial or any reparations that had been done?
So that night, the gentleman I met and told him I didn't have it in my county, and he told me I did. I was like, well, we need to talk, obviously. He finally come to my office probably 2.5 years after the event is when I met him. Officially got some information from him, and I asked for a map, just because I didn't know where the pipeline was, right? So he gave me a map that looked like a preschooler drew, with the outline of my county, literally, and a line that went through it. And that's their pipeline. Now, since then, and since probably litigation and some other things that may have went on, I have no idea, we've gotten some decent quality maps, but that was the first map I got. I I knew it went across the north end of my county. That's it.
Nothing on structural integrity beyond that today.
Now, since that day, I believe that particular pipeline was bought out. We've gotten a lot of good stuff. I had a group of firemen that returned last night from College Station that had been in training for pipelines all weekend.
Is there a root cause analysis for that report, for that incident?
Yeah, I know that NTSB, along with PHMSA, did an investigation on that matter, and I want to say it was earth movement that wound up causing
geoslide.
A geoslide that wound up causing that rupture.
Gotcha.
And that report you should be able to access that report online from
So it was a
NTSB.
structural failure due to foundation settling or something like that.
Yeah, obviously our geography is a little different than what y'all have here.
Right.
And back to kind of what you said, where Satarsa, Mississippi was located was in a valley, basically. So everything that came from that pipe, it dropped down into their town. I don't know how it would affect flatland, per se.
Thank you very much.
Yes, sir.
Thank you, Vice Chair Orgeron. Question, Representative Bryant? Has Mr. Lacombe?
Yes. Yes. Depends on how good I do. You could say Lacombe. Right. Yes. Yes. Someone mentioned, another rep brought up, we had some earth movement here in Louisiana over the last couple of years. Is there precautionary steps with that? Now we are having earth movement here in Louisiana to prevent the type of breach he's talking about?
Right. So pipeline operators have what are called integrity management programs. And through those programs, they are to assess all the risks to their pipeline and take preventative mitigation, measures. So should earth movement, whether it's seismic or any other type of earth movement, come up as a risk, as a threat to that pipeline, then operators are expected to be proactive in their maintenance and monitoring that and making determinations if that is a threat to the integrity of their pipe.
Okay, so there's no, since we've had earth movement in Louisiana, did that affect your pipeline?
We've had no pipelines rupture due to earth movement here, yeah.
But you are aware of, is the earth
We are
movement
aware
was-
that there have been some issues up in North Louisiana.
Okay.
Here recently, in fact. There have been a few reported seismic incidents that our office, through our injection mining division, is addressing right now. I'm not aware of any in South Louisiana.
Okay.
Where it appears the bulk of these projects would likely be located.
In South Louisiana?
Yeah.
Right. Okay. But you are doing some work on trying to understand what happened in North Louisiana?
Yeah, the Office of Conservation, like I said, I believe we're looking at the wastewater injection wells up there as potentially being a source. The pipeline division isn't actively investigating that. It's another division in our office.
All right. And I think Representative, my colleague Orgeron, asked about that remedial measures that had been taken for that breach. What came of that? Which changes in the pipeline because they had to repair it, right, if it breached?
They would have to make the repairs. Now, whether or not the operator has, amended any procedures, I'm not familiar. Again, we don't regulate that particular line.
But do you know what remedial measures was made when they went in and made the repairs?
In Satarsa?
Yeah.
So it actually ruptured under a road, or just as it crossed under a road inside the hill. The side of the rupture has been greatly reinforced, and it's probably a 200-foot retaining wall on the side of the road where the pipeline crosses under. I was up there not too long ago looking around, and my only question was, if you did it on one side, wouldn't you do it on the other? And it has not.
Right. So they did take some measures.
They
but
did. They did.
It was a Band-Aid, or not a full Band-Aid, you believe?
Well, and their studies probably showed something different. Maybe they didn't see any erosion on that side, or whatever the case may be. But they did
do one side,
yes.
But it's not the other side of the road.
That's right.
Gotcha. Thank you. How did I do? No. How did Jeremy do?
Thank you, Representative Lacombe.
Thank you. Yes.
Next question, Representative DeWitt, to which Representative Landry makes a motion. You're limited to 3 minutes.
Yes, sir. Thank you, Mr. Chair. Real quick, Jerry, thank you for coming.
Yes, sir.
Fellow first responder, made many spills and pipeline ruptures over my career. I guess he answered some of the questions Mr. Vice Chair did. Basically, what would you do again? Post effort, afterwards, would you do? You've obviously gotten some maps to upgrade your area. Your area, did y'all have some more training? Did y'all, for pipeline safety, as a fire department, did y'all buy some more air monitors? Just whatever.
So we were given some air monitors, obviously, and I can't speak for the county involved. I think they got theirs first. We got ours 3 months ago, 4 months ago, whichever it was. But for me, I don't need air monitoring. The air I breathe is going to be great.
Yeah.
I'm going to bring my own to the party. The air you breathe, probably not so good.
Yeah, but what kind of monitor do you have? Because who knows, who told you that it was CO2, first of all?
Finally, the pipeline, the entity involved, our EOC or their EOC, called them and they said, "Oh yeah, by the way, we do have a leak happen an hour and whatever ago."
I got you, Mr. Steve.
Yes.
What does Louisiana do with our local fire departments and things like that? Do y'all provide them, or how do they know about maps that they can possibly get to? Because we have lots of pipelines running across our interstates and things like that, and I'm a volunteer fireman in our little community, and I was just wondering, He didn't know his pipeline was there. He's been chief 20-something years, correct? If somebody in another fire chief in an area, can they get a map of their district?
They certainly can, and unfortunately they weren't aware, and I don't want to. If they weren't aware, that's a failure of the pipeline operator. Okay, pipeline operators have a lot of regulations that they have to follow. One of which is public awareness. Every pipeline operator has a public awareness program where they would communicate with the public, with local officials, with first responders on the location of their pipeline, the product it carries, the danger to the public, how to recognize a leak, what to do when you see a leak, right? And many pipeline operators will conduct drills, and they'll invite the regulators in and the first responders in, and they'll have mock releases, ruptures, whatever that scenario is, and so that they can all work on coordination should an event actually occur. There is the National Pipeline Mapping System. Mm-hmm. That system is maintained by PHMSA. Anyone in the public can access that system to see pipelines in their parish. And I know that the Governor's Office of Homeland Security and Emergency Preparedness, which coordinates with a lot of with the parishes around the state with their emergency folks, is familiar with that website. And hopefully our folks in the parishes are familiar. Hopefully our operators are doing a good job of public awareness, and hopefully they're doing those those drills. Well, not hopefully, they are, because we inspect them and make sure that they are, at least the intrastate ones. Right. And so there's plenty of information out there, and there's plenty of regulations in place for operators to make folks aware who need to know, and to make the public aware, because they can be their eyes and ears as well, right, for smaller leaks and whatnot.
Right.
To address those.
How often do y'all make the industry, the community, do a pig test or some type of tightness test on those lines? On those, can you go over that with my other colleagues?
Sure. So again, I talked a little bit about the integrity management programs. And so when you talk about a pig test, right, we're talking about inline inspection tools. We call them pigs. and a lot of times I run a smart pig,
Right.
which is more or less taking an X-ray of the pipe, but they can detect corrosion, cracks, dents, and so those are run on, if we're going to talk about CO2 lines, because we have the gas code and we have the liquid code, and they have some different requirements there. On the liquid side, those are to be run at least once every 5 years for those lines in high consequence areas. I talked about high consequence areas a little bit yesterday. It can be run more often than 5 years. Certainly, if you are detecting some corrosion on your pipe, you may want to run it sooner than 5 years so that you can then measure that rate of growth, or maybe determine that it's not growing at all. And maybe you can go back to that 5 years. But the 5 years is the maximum. You also can use a pressure test in lieu of an inline inspection. Check, make sure the pipeline is still holding pressure at that maximum allowable operating pressure. So
we have things in place.
Absolutely.
Yeah.
Yeah.
I just wanted to make sure our members knew that.
Sure.
Well, we're aware of that.
Sure.
Those regulations are in place. Too, I don't know if Louisiana's ahead of Mississippi on this one, but
well, no, that Mississippi enforces the same rules, but actually Mississippi doesn't have a liquid program. So if there are any intrastate CO2 lines in their state, the federal government regulates those as well. We do have a liquid program here in Louisiana.
Right.
Yeah.
Okay.
But and kind of further on that, we've always had a dinner and a show. We do that every year. And what I mean by that is all the pipeline groups get together and they cook catfish or whatever mostly for the contractors and the utilities or whatever, but the first responders are involved too. And you sign a master roll sheet, right?
Right.
And they may give away a flashlight at the end of it.
Right.
But you really don't have that interaction individually with the pipeline group that this is what we're carrying, this is what we're doing. And the biggest thing, back to what you were asking earlier, I'm going to have good air. How do you let your community know they have bad air?
Yeah.
You don't.
And I'll add to that. So we are a member of the National Association of Pipeline Safety Representatives. It's a collection of the state pipeline safety programs. And I am their representative on an API committee right now that is developing a recommended practice on public engagement. And so engagement would go a step beyond awareness, right? Awareness is we mail you the mailer with the information on the pipeline, and here's our phone number, and here's how to recognize a leak. But engagement, while it would not be a regulation, it would be a recommended practice. That operators go a step further in actually having those town hall meetings and providing information and getting feedback from the public on their operations. And it actually starts in the planning phase of a pipeline. It's not just during operations. It's for the life of the pipeline. And so we're close to completing our work on that. Hopefully, maybe in the next few months, we'll have a finalized RP for the industry to use to develop their own public engagement programs and maybe fix some of these gaps that we have seen in the past.
well, as you'll find, Steve and Jerry will probably ditto that. Is these things seem to happen at night, and I'm not sure why, but it seems like after hours is when all this happens. So trying to get in touch with that pipeline person or run down whose it is and that sort of thing can be a challenge sometimes. Mr. Chairman, I think my 3 minutes is up. So
And then some.
I'll leave it with that.
And then some. You might have used up Representative Landry's 3 minutes, too. Thank you, Representative DeWitt. Representative Landry for a question.
Thank you, Chair. Mr. Jerry, I want to thank you for coming here. Your testimony, I think, has a huge part of us looking at all these things and different issues to make sure that with this moving forward, all parties are safe, and we assure that everyone's breathing air is as best quality as possible. Mr. Steve, this question is for you. My background is oil and gas pipeline, and so is there any regulations that we'll look at for this where, we use, if you use Schedule 40, Schedule 60, 80, 120, 90 in pipe size or diameter, circumference of thickness, or coatings? I know in pressure we use different sizes, but are we looking at any regulations as far as what we're going to require for this pipe that we actually putting in the ground?
Well, there are requirements right, for pipe design and for the operating pressures, right? So the thicker wall pipe you have, the higher you can operate your pipeline at. A thinner wall, then you're going to be limited by design and by your pressure test prior to putting the pipeline into service. And then, operators will assess over the life of that pipe whether or not that MOP, that maximum allowable, that maximum operating pressure is still appropriate based on the current integrity of the pipe. So there's nothing specific saying you have to use Schedule 40 or Schedule 60 for a carbon line, but you're going to have to meet design requirements for the pressures that you want to operate at, right? And that's not just for the pipe, but that's also for valves and any other equipment on that pipeline. That's already kind of in the code, right? It's just not specific as to what you have to do. It just gives you what your limitations are with each type of pipe you're going to use, right?
So basically, we're using either whether the DOT regulated or...
We're using the DOT regulations for that, yep. Mm-hmm.
Thank you.
Yep.
Thank you, Representative Landry. Representative Mack for a quick question.
Thank you, Mr. Chair. These are quick questions. This is for Mr. Steve. So I read in an article that the regulations when you were transporting CO2 as a gas versus a liquid were different. Is that true? Can you speak to
it? It is. So Louisiana is maybe the only state that has safety regulations for transporting CO2 in a gas phase. The federal government is, they are developing a notice of proposed rulemaking as we speak. They want to have one out here in the next month or two, NPRM for short, for regulating CO2 in a non-supercritical, right? Because it can be in liquid phase, but still not in supercritical phase. And so, so there will be federal regulations for CO2 in a gas phase. I'm not aware of any pipelines that currently transport CO2 in a gas phase, not here, and I don't know about anywhere else. Maybe they do exist. But when CO2 was added to Title 49 CFR Part 195, it was included in the hazardous liquid code, and it was specific to CO2 in a supercritical phase. So you're correct. You're correct about that. Yeah.
Thanks for answering that question. I don't know if you know the answer, but I was just the pipe material that CO2 is transported in, and then can you speak to what type of joint connection is made, when they're putting these pipelines in?
Well, I mean, they're going to weld steel together.
It's welded.
Right. And so the code requires, on liquid code, that, the pipe or the product be compatible with the pipe, or the pipe compatible with the product that is transporting. And so, obviously when you introduce water, whether it's into CO2 or natural gas pipelines or other lines, it can cause, it can be corrosive, right? And so operators do monitor that moisture content in their pipe to prevent corrosion. So I know there's been a lot of talk about, what type of pipe, and, operators should be mindful of the code and what type of pipe they're using when they're transporting different products.
Okay. Thanks.
Thank you, Representative Mack. Representative Owen for a question.
Very quick. Thank you, sir, for coming. It's my hope, Mr. Steve, that the state will take into account the lessons learned in Mississippi. I've heard you say that repeatedly. Please know we will hold you and the agencies accountable to that standard. Because if you absorb something like this and you see it and you take into account what happened and you prepare for it, then you've done everything that you should and that we should as public servants. We're gonna sign up to this, and let's do everything we can to make sure it's right for the citizens. So more to follow, but thank you both for your testimony today.
Thank you.
Yeah, and I would add that one of the more recent regulatory requirements for pipeline operators is a new rule that we refer to as the rupture mitigation valve rule. was effective in 2023 that requires certain types of valves be installed on newly constructed pipelines and has spacing requirements for it, such that those valves are either going to be automated shutoff or remote controlled valves. And with spacing not more than 15 miles apart if it's through an HCA, 20 miles apart at non-HCAs, such that you can isolate the pipe quickly and that you have a smaller section of pipe to isolate. Such, when he mentions the pipe was shut off within an hour, but it continued to leak for 4 hours, right? Well, if you can limit that pipe that's actually going to have to leak, right, you can limit the amount that gets released. And so that's a good rule that was put in place by PHMSA, and we've adopted that regulation.
Okay, there are no further questions. Thank both of you very much for your presentation. We learned a lot, and it's very informative. Thank you for your service
Thank you.
for driving over here from Jackson, Mississippi.
Vicksburg. Yes, sir.
All right. Well, thank you. Be careful going back home.
Thank you.
All right. We are now in public testimony. We have one only so far. One card to speak. Logan Burke. Logan, are you here? Logan? Okay. Please identify yourself for the record and what you're going to speak on, and you have the floor.
Sure, thank you. I'm Logan Burke. I'm the Executive Director for the Alliance for Affordable Energy. I'm going to speak today about something that has not been touched on here, which is utility costs. Now, I do most of my work at the Louisiana Public Service Commission and the New Orleans City Council. But if this hearing is about receiving information that impacts your constituents, I thought it was important to share it with you. Carbon capture and storage, most of what we've been hearing about its purpose is for things like hydrogen, blue ammonia, various kinds of refineries and petrochemicals. But another purpose of it, or proposed purpose of it, is to retrofit and build new power generation that would capture the carbon and then move it and store it somewhere. I'm sure all of you pay a utility bill. If you live in Louisiana, you know what our utility bills look like. The thing to know is that right now, according to our best data from federal labs, national labs, the cost to retrofit a natural gas-fired power plant with carbon capture and storage is roughly double the running cost of the least cost resource, which is onshore wind and and solar, not to mention energy efficiency and demand-side management. And I bring this up in large part because there are 3 power plants right now in Louisiana, existing power plants, that the owner-operators are considering retrofitting these power plants to include carbon capture and storage. And the reason that is different than the kinds of industrial uses of carbon capture and storage is that on power plants, we pay. Whether it works or not, we pay for it. We pay for everything that a utility buys, and we pay for all of the fuel, we pay for their taxes, and we would most certainly pay for the retrofitting of these power facilities with carbon capture and storage on them, whether new or retrofit. And I want to point out to you that this is a serious risk. It is a risk that there are already 3 power generation facilities that are being considered for carbon capture and storage retrofit because of the risk of failure or underperformance or waste of money or all of the above. Right now, there are 2 power plants in the world that use carbon capture and storage. Neither of them, I should say, have ever met their expected designed rate of storage, or rate of capture, rather. All of them are designed to capture 90 to 95% of emissions. None of them have been able to consistently and maintain a capture rate above 70%, 75%. Usually they're capturing in the 65% range. And what this means is that even with the very generous 45Q tax incentives, federal tax incentives that you've heard about, if these power plants aren't able to meet the level of capture that they're promising, the costs of those plants will skyrocket. And that is in addition to the fact that anytime these power facilities in the world have been built to capture carbon, the costs have then doubled and tripled over what was expected, even apart from whatever kind of tax incentives that were promised. And the reason that is such a risk in a place like Louisiana is because we, as I mentioned, we are, as constituents, as ratepayers, as customers of utilities, we are on the hook for all of the costs, right? And so that means if something fails and does not meet its expected or designed outputs, it means that ratepayers will pay the cost. You might have heard of something called Little Gypsy here in Louisiana a number of years ago, back in the late aughts. A power plant owned by Entergy there was an expectation and a plan, and in fact a significant investment in retrofitting that power plant to do something else, but the point is to retrofit it. The Public Service Commission at that time said, this is prudent, you can move forward, you can begin the work to do this thing. The utility spent $300 million and then abandoned the plan. We are still paying $200 million as a result of that failure, even though it never did what it was promised to do. Even though the plan was arrested halfway through the development, the point is we are at risk. Your constituents are at risk. Anybody who pays a utility bill, who is basically a captured customer of these utilities, would be required to cover that risk. And so I wanted to make sure that you were aware of the kind of distinction here between the kinds of costs that your constituents are on the hook for and the kinds of costs that industry would otherwise be on the hook for things like petrochemical facilities and so forth. So I just wanted to fill you in on that and make sure that you know that it is up to the Public Service Commission to make decisions about whether these kinds of things go forward. But I also want to point out that this legislature a couple of years ago, and I'm almost done here, thank you for your time, a couple of years ago, this legislature passed a Utility Energy Transition Securitization Act. And what that was intended to do, or one of the things that is potentially intended to do, is to shift the cost further of the risk onto ratepayers for basically abandoned costs or facilities that don't meet their promise, right? And so while the Public Service Commission does make the decisions about where our power comes from and how much it costs and so forth, this legislature does have responsibilities associated with those long-term decisions and how they impact us. So I just wanted to share that. Thank you for your time.
Logan, thank you very much for coming. We do have a quick question. I would remind our guest colleague that we're getting a little bit off the agenda on this, so try to keep it quick.
That's okay.
Go ahead. No, go ahead. You got it. Hang on.
Tell me where those 3 locations are.
Yes. One is a power plant called Madison 3. It's part of the Brame Energy Center owned by Clico. It's in Rapides Parish.
Rapides, okay.
Boyce. Another one is the Lake Charles Power Plant, which is an Entergy-owned plant, right where it sounds like it is. And the other one is a power plant owned by Occidental. It's called the Taft plant, and it is in the river parishes. It's in Taft.
Okay, thank you.
Yeah, thank you.
Thank you, Representative O, and thank you very much for being here. Appreciate you. There is another question. I'm sorry.
Oh, I'll just keep sitting until.
What
This
was
is the last question. We're not taking any more.
What was the act you said they passed?
It was called the Utility Energy Transition Securitization Act. And I believe that was last year and the year before, there were adjustments to that, to existing legislation associated with securitizing things like storm debt.
You know the author?
I do not.
Okay. Thank you.
Of course.
Thank you. Again, thank you, Logan. And thank you, Representative Landry. That is it on a motion by Representative Lacombe to adjourn. Is there any opposition? There's no opposition.
It felt like it.
Well, 50 acres was the well. We were structured, it's just too big, but the property itself.
That's fabulous.
For the jobs, because the people in my area need the job. The oil and gas is depleted, so this is an alternative revenue stream that doesn't affect the oil and gas. How's everything? Good. I was actually going to hit one too. But where you stand? We're going to bed at 4 o'clock. As far as, I don't think they suspended the rules. They may come back tomorrow. Yeah. I'll let you in time today.